Hello, my friends, and happy Sunday. Today is Sunday, October 13th, 2024. And thanks so much for coming to hang out with me a little bit today. And Mark Bederow will be joining after he's finished watching the tragic New England Patriots game, which there are 2 minutes and 50 seconds left in the fourth quarter. And sadly, they are losing 41-21 against the Houston Texans. Sorry, guys. Anyway, I thought I'd come on a little bit early before Mark joins us so that I can read the documents to you. There was a document dump on the Karen Reed case on Friday. They are, they have a new DA or special DA or whatever they're calling him, special ADA, Hank Brennan, who, as you know, represented Whitey Bulger in his criminal case as a defense attorney. And now he has been tapped by the Norfolk County District Attorney's Office to retry Karen Reed beginning in January of 2025. So they did a document dump, a discovery dump on Friday, as always happens, right? On Fridays. And they're turning over 50 pieces of new evidence. And they also filed a motion because they want to schedule a reassembly and testing of the defendant's Lexus telematics system. So this is interesting stuff. Let's get into it. We are very collaborative here, so I'm going to use you guys to help me figure out what some of this stuff might be. The 50 items of discovery that were turned over in the Commonwealth's Notice of Discovery, XLVII. Who's good at Roman numerology? Add it up for me. XLVII. It's a lot of stuff. A lot of stuff. And when Mark comes on, he can try and help us decipher exactly what all this stuff means and the relevance of it. I could do that by myself, but it's so much more fun when Mark's here with me. So let's get into it. Let's take a look at document number 391, Commonwealth's Notice of Discovery, XLVII. It's like a Super Bowl number. That's how big this number is. 47? Yeah, 47? All right, I'll take your word for it. Or is it 47? All this stuff. There it is. Nope, no more taillight pieces showed up. No, but they want another go. They want another go at the telematics system, which we're going to replay some of Trooper Reno's testimony because he said the thing was destroyed. So I don't know. Did it miraculously repair itself? Maybe. That's what I'm thinking. I guess that's what they're thinking. And they found a couple more experts to come in, and perhaps means they're distancing themselves from Trooper Nick Guarino and Trooper Paul. We're counting. Now we're trying to figure out what XLVII is, because this is the new Notice of Discovery, dated. Oh, come on. I like continuous scroll. You know, I like a continuous scroll. This is dated October 10th of 2024, but I think it just hit the docket. Oh, don't worry, Mark. Whenever you're able. Whenever you're ready, Mark. I started without you. It's cool. I know you might have to wipe off some tears for your Patriots, and that's okay. It's dated the 10th. It hit the docket on Friday, and here it is. Lots of new stuff. Let's check it out. Well, it's definitely not 48 because that would be VIII. 47, whatever it is. Whatever it is, it's a lot. It's a lot. I know that V plus 2 is 7. Okay. Here you go. Now comes the Commonwealth, and the above caption matter indicates that of this date, the following discovery and materials have been provided to the defendant through defense counsel. Number 1, copy of a letter from Chief Helena Rafferty of the Canton PD dated 8/21/24. Anybody have any idea what that is? Chief Helena Rafferty wrote some letter on 8/21/24. Maybe it has to do with one of the internal affairs investigations. I'm not sure. Number 2, copy of Canton Police Department Sally Port video dated January 1, 2022 as recorded. And then it says inverted. Look, notice how they're pointing out now that it's inverted. They're giving a disc. I don't know if that's a typo or if this is actually from January 1st of 2022. Remember, the death of Officer John O'Keefe was January 29th of 2022. So that's interesting. Either it's a typo or are they trying to show that, oh, yeah, we got a new system as of the new year in 2022, and it was inverted, and it's all inverted, and that's just the way it is, and that's just the way it records. We'll talk to Mark a little bit more about that because I was talking to him about that this morning, about that inverted video and what that means for the new trial. Number 3, copy of Canton PD interior hallway video, exterior parking lot video dated January 29th, 2022 at 1 a.m. What do you think happened in the interior hallway and exterior parking lot January 29th of 2022 at 1 a.m.? Is that going to be Higgins showing up at the police department at 1 a.m.? I don't know. Thoughts? That's what Jules says. Jules, I hope you're okay from the hurricane. I heard you were right in the path of Milton, and I hope you're okay. And also, Jules, just as a side note, the Manatee County like website has been down for days, for like a week. What happened at 1 a.m.? Higgins staggers in, maybe? Maybe Higgins staggers in. But again, why are they going to go on the defense again? What time did Higgins say that he left 34 Fairview? We'll get back to that. Keep that in mind. For those who are just joining, we are reading the discovery document dump that happened or was logged in with the court in Norfolk Superior for the Karen Reed retrial, which is scheduled to start in January. This is all the new evidence, the new document dump by the new EDA, Special ADA, Hank Brennan. Number 4, copy of the curriculum vitae of Colleen Crawford, 3 pages. Colleen Crawford is a certified forensic video technician employed by the Norfolk County DA's office, and she's been employed by the Norfolk County DA's office for the past almost 19 years, since February of 2006. But now she's going to be a witness. Number 5, copy of quick hash report of Colleen Crawford dated October 8th of 2024, which is a 9-page report. Number 6, copy of extracted frames report of Colleen M. Crawford, dated 10/7/24. So these are all new reports, new evidence that they're just generating as of a couple of days ago. And it may have something to do with that video because it's extracted frames. So let's see. Number 7, copy of the extracted images from the extracted frames report by Colleen Crawford, dated October 7th of 2024, which is on an external hard drive. A CV, yeah, a CV is evidence. Well, this is an exchange. It's an exchange. They're doing an exchange. They're exchanging the documents. That's what they're doing. 50 of them. Number 8, copy of clarification report of audio file 272.amr audio by Colleen Crawford, dated 9/26/24. Evidence is all of a sudden revealing itself, Emma. This is exactly what I was thinking when I was reading this. It's all just now revealing itself. Are they now clarifying the audio? Now they're going to clarify the audio for the retrial? Which audio? Well, it may be this audio. Copy of the converted reduced speed amplified audio file 272, a voicemail message with and without text overlay of Colleen Crawford, dated 9/26/24. Are these Karen's voicemails to John? I don't know, because that's the only information they're giving us, is that it's audio file 272. And that's on flash drive. 10, copy of the surveillance video clarification report of Colleen Crawford in July of 2024. So that was immediately right after the trial. What are they clarifying? What video are they clarifying? That fuzzy video from the library where a car went by and they wanted everyone to believe it was Karen's car? I don't know. 12. 11, sorry. 11. Copy of Canton Police Department Sallyport video clarified. 1 flash drive. Clarified meaning it's going to be clearer and sharper, or clarified meaning we're going to clarify to you now that it's inverted. I'm not sure. Yeah. Yeah, Suze, it's an October miracle. Can you believe it? Thank you. Did you mean the Patriots winning, or are you meaning this? Yeah, no, the Patriots lost. It's over. It's over, my friends. It's over. Sorry. Sorry for your loss. Thanks, Suze. Might be from the 413. Thanks. It says it's 58. Thank you. Thank you, Della, for thanking me and Mark. And here's Mark. Hey, Mark.
How are you?
I'm so sorry for your loss.
It's okay. The Patriots stink, but I think they have a quarterback, so that's a win.
Well, that's good.
Yeah.
All right. This is I'm just starting to read through the 50 new items of discovery. So if there's anything you want to add to this, I don't know what this letter from Chief Helena Rafferty was from August 21st of 2024. Thoughts?
Please make this stop. Get them off my back. I don't know.
I don't know if
maybe it's just a cover letter saying, enclosed herein, please find. Who knows? I don't know.
And then we got this Sallyport video, as recorded, inverted, but it says January 1st. So I don't know if they're going to try and say this is a new system we got as of the beginning of 2022. And look, it says it's inverted. So all the video is inverted. I don't know.
Could be, I guess, although that's hard to believe.
Or a typo. Could be a typo.
Could be a typo. I'm not sure
and
why.
They've got that. What?
You're just saying, I don't know why they'd have inverted video at all. So, could be a typo. Could be they're trying to show that's the system the way it was. So there's nothing unique about that day, I suppose.
Nothing to see here.
But it doesn't help them. It may take away some of the sketchy factor, but it doesn't change the fact that the car is flipped. You can't see the taillight and you can't see Proctor. So, it's still a problem.
And the fact that Lally introduced that piece of evidence as being a fair and accurate representation of the Sallyport on that day and had Buchanan testify to that. That's a problem.
I would think they would want to drill down on when they first spoke about that, when they prepped, how many times they viewed it together, who else viewed it, those sort of things. Yeah, it's not, it's window dressing. It's not going to fix the ultimate issue, but it's something, I suppose, for them, if that's what it is.
And here's the Canton PD interior hallway video, exterior parking lot video, January 29th at 1 a.m. I don't know. Is that going to be Higgins stumbling in?
Playing bumper cars, moving cars out there. Who knows?
Right, to show that he was moving cars. But again, what are we playing defense now? We're just going to come in and prove that Higgins didn't lie?
It's fascinating, though. They are bait stamping, although you would usually call it Bates stamp, not bait. That's weird terminology. But bait stamping is identifying each document with a unique number, which makes it harder to claim you didn't get things. I don't know why they wouldn't have done this in the first trial for a case with this much material. That's nuts. At least, if nothing else, he's doing this in a way where you can document what's being discovered. But I've never heard anyone call it bait stamp as opposed to Bates with an S at the end, but whatever.
Exactly. And notice that this first one is number 1. So this is the first that they're doing it in however many years they've been prepping this case for trial.
Right. But Bates is like the company. It's Bates with an S. It's just
right. Correct.
Strange terminology,
but new special DA, new special rules, I guess.
I think it's good. Hey, tax dollars for something. That's good.
He's already probably burned through his retainer with all this stuff, but that's a matter for another day at $250 an hour. It's only 300 hours. So this CV of Colleen Crawford, she's been with the Norfolk County DA's office for 18 years. She's their certified forensic video technician.
And yet had nothing to do with the first trial.
Nope. Nothing. But now they're going to, it looks to me like they're just going to bring in all new witnesses.
Well, how they you de-ice an airplane, they're de-icing the Massachusetts State Police from the second case as much as they can. I mean, it seems clear they obviously want to get rid of this Trooper Paul guy. They almost certainly are going to get rid of Proctor. It certainly seems, based on the stuff that you're looking at now and some of the other stuff you'll look at in a little bit, that they're attempting to move away from Guarino. So clearly they are attempting to push away from the state police. Now, the snivelly part of me or someone else or snarky part might say, by replacing them with a career person at the Norfolk DA's office, I don't know how much that moves the ball, but I think clearly what Brennan is trying to do is get rid of as much as possible the state police argument that the defense would make.
Seems that way.
Yeah.
And then Colleen Crawford did this was just done last week, a quick hash report, an extracted frames report, a copy of the extracted images from the extracted frames report, all done last week, clarification report of an audio file. They don't indicate what it is. And then a converted reduced speed amplified audio file of a voicemail message with and without text overlay. That looks like it could be one of Karen Reed's voicemails to John.
Yeah, maybe in the background you can hear her whispering to somebody saying, "No, I really did it." I don't know. But I mean, I think, again, anything that she's going to testify as a witness, they're having her do it herself as to not rely upon anything that the state police did. So she can say, "I looked at this with my own two eyes. I listened to this with my own two ears. Here's what I believe. I'm not relying upon anything that Guarino or any of these other people did." I mean, he's, as much as he can in a couple of months, it sounds like trying to reboot the evidence, if that makes any sense.
Yeah, it absolutely does make sense, because they're not going to be reliable witnesses, because they're all, a lot of them, many of them are impeachable now that the Birchmore evidence has come out, and evidence that I've pointed out came out in the Brian Walsh case and other cases that these investigators were involved in. So makes
Right.
perfect sense. Then they've got a surveillance video clarification report, copy of the Canton PD Sallyport video clarified, meaning clarified like it's going to be a clearer version of the audio.
I don't know what that word means.
I mean, video.
I
Right.
don't know the word I would use what I think they're talking about in my experience is enhanced. You enhance video as a clarify it, but when you use the word clarify, it sounds like something was screwed up and now we're making it clear. But I don't know what he means. But it's not uncommon to attempt to enhance grainy or not great video through any kinds of technical expertise or whatnot. So that might be what he means. I don't know.
Right. That's because I would think clarified means, yeah, we're going to clarify to you now that it's inverted. Like now
Right.
we're, right? Instead of like it's enhanced. And again, clarified images from Canton PD Sallyport video. Here come the grand jury minutes from March 27th of 2024, all of them, and the exhibits. This is the grand jury where they tried to indict Aidan Carney and Karen Reed for colluding or trying to conspire to intimidate witnesses, correct?
Yeah, no, I mean, obviously I wrote about this transcript in September, so that's exactly what it is. It's kind of surprising for a lot of reasons that the Karen Reed defense team was not made aware and not provided this evidence. I don't know, maybe 5-6 months ago. Certainly, I don't know. I don't think you and I have talked about it, or maybe we did.
I don't think it was ever turned over to them.
No, what I mean is, but what happened in May during the trial, when they were trying to exclude someone else from the courtroom, and as part of the alleged conspiracy between Karen Reed, Aidan, and her lawyers. I mean, they threw her lawyers in there just for shits and giggles. Why not in a publicly filed document, and did not notify the court or defense that, in fact, that what they believed had been completely rejected by a grand jury. That's unethical. I mean, there's no other way to get around that. You have an ethical obligation as an attorney to notify the court of any material facts that are relevant, that you're aware of, that others may not be aware of, that could affect the court's determination. And if the court, in ruling to exclude him from the courtroom, at least during certain witnesses, I don't know that she would have relied upon this fact alone. But if you're going to give the prosecutor's opinion in a public filing that the media could have picked up on in the middle of a jury, literally in the box, it might seem ethical and appropriate to notify that, although that's our theory, a grand jury found that there wasn't even probable cause to indict, and that in fact their theory amounted to nothing more than communication between a criminal defendant and a reporter, which happens every single day in 50 states and elsewhere. And it's just not that big a deal. I mean, that's what reporters do. They get sources, and any reporter who gets a defendant as a source, that's the gold standard, really.
Mhm.
And if they print or don't print, whatever, but somehow how that translates into probable cause to believe that they were intimidating witnesses, that's crazy. I mean, that's just pure conjecture. And to make that allegation in a public filing and lump in her lawyers, that's clearly designed to hope that the press would pick up on that and really throw her for a loop in the middle of trial, which could be extremely prejudicial if people find out. I mean, you don't want the jury to find out. They're not supposed to pay attention to the press, but do they? Who knows?
So just a little louder for those in the back. Karen Reed communicating with Aidan Carney. There's nothing wrong with that. There's nothing wrong with that.
No, that happens all the time.
Allowed. It's really perfectly acceptable. And just because she chooses to speak to a reporter during her trial, whenever, it does not waive her Fifth Amendment right in the civil case that she must testify. People are so confused about that in the netherworlds of, cesspools.
I saw last night, or somebody sent me, it was on, the show, the Aidan show last night, where they played a clip of Court TV. Again, was it Julie Grant, Coffindaffer, and two other guys analyzing this pre-indictment about how serious it was that there was communication between a criminal defendant and a journalist, 180 whatever phone calls, and that there was evidence that the reporter had spoken to the lawyers, and they were having conniptions over how inappropriate and how powerful and outrageous this was. And I'm sitting there laughing, thinking, again, every single time there's any case that gets in the media, what do journalists do? They call lawyers. You don't even know who's calling who, but it happens all the time. And it doesn't mean that whether you think, oh, they shouldn't be talking or not. The issue that these four people were talking about on Court TV and that Lally was misleading Cannoni with is this idea that because of that contact, that somehow the four of them or five of them, all the lawyers, whoever, were somehow conspiring to intimidate witnesses. That's why they were talking, as if they were pulling strings and using the journalist as the so-called useful idiot, as the puppet master to intimidate these witnesses. I mean, this is just crazy land.
Well, here's a question for you from Susan. They withheld the grand jury minutes from 3/27/24 from the defense in the first trial. Is this Brady material?
No, not necessarily. I mean, I'm not going to get into the content of the transcript. Obviously I've seen it because I have it. The only thing I would tell you about the transcript itself, and I would say this because this was in a publicly filed document by Cosgrove to us, so it's out there, is that the entire grand jury presentation consisted of one witness, and that was Brian Tully. That's it. Which also means, as you can imagine, Massachusetts, they use hearsay, and it's regurgitating information that he was provided by others. Some of that, if you go back and look at other publicly filed letters of people who were providing him information about Karen Reed and Aidan, you can use your imagination and figure out where some of that comes from. But is it exculpatory that they didn't indict her for witness intimidation? No, I don't think so. could one argue that they should have disclosed the transcript because it was a prior statement of Tully and it's something that they might have found value in cross-examining him on? Different question, maybe. I think most prosecutors would do that. However, the fact here that not only did they not do that, but they filed a document saying we believe they did the crime in a public filing, knowing with actual knowledge
Right.
that a grand jury didn't even find probable cause. And, I said this to someone else the other night. If I were Karen Reed's lawyers, I'd be making a real stink about that and considering disciplinary sanctions against the people who filed that motion. Because also, if that factored into the judge allowing some of that evidence in, which could have, who knows, could have persuaded some of the jurors, as you know, at least one of the jurors told Aiden later in some interview that we knew who you were. And we heard that there was intimidation evidence in the trial. And did that prejudice her? Who knows? But it's unethical. There's no way around this. And, you can't help but notice the timing of this disclosure. There were news articles about the No True Bill on, I think, the day before or thereabouts. And the next day, the new guy in town, to his credit, gave them the transcript. But the real question is, why the hell didn't anyone else in the DA's office proper, meaning not the special ADA they had to bring in to do this right, why didn't that happen earlier?
But if Lally misrepresented to the court subsequent to March 27, 2024, that they were investigating this after the grand jury came back with no true bill, that's a big deal. That's a misrepresentation to the court as an officer of the court. That's bad. Guys, that's bad. It's sanctionable. It's
a material misrepresentation by omission, which is the same thing as affirmatively misrepresenting. I mean, if you skew facts in a way that it is designed to mislead, or that you are withholding information that could be material to the court's consideration of the issue, then you have acted unethically. And if he chose, for example, in his motion to leave out the editorializing that the Norfolk DA believed that Karen Reed, her lawyers, and Aiden Carney were conspiring to do these terrible things, they might have a credible argument to say, well, whatever. But the fact is, they put it in there, gave it to the judge, didn't tell her that those charges were dumped by a grand jury who couldn't even find probable cause based on hearsay, which is as low an evidentiary standard as you could possibly imagine.
Yeah.
And also, it was put in a publicly filed document. And I think that's part of the thing that people need to understand. If a journalist had read it carefully and thought about this, they could have published an article saying, wow, like they're accusing Karen. I mean, nobody was going to care about Aiden for that. It's Karen's trial, but she's got a jury. And if the lead of the story would have been he's accusing her lawyers. I mean, that to me, is the thing that really jumped out, that the DA's office was accusing her lawyers literally on trial in front of a jury of conspiring with their client. And the other thing is this: if he really thought that was true, okay, where was a stronger motion previously to kick them off the case under a conflict of interest? Because if I know he made some rumblings earlier about, I don't remember the exact issue, about whether she needed new counsel or whatnot. But the reality is, if the lawyers were part of the criminal investigation that they were investigating, then they would have had a conflict. They can't represent their client when they're being accused of being co-conspirators with her. I mean, I think, anyone's third grader would recognize that the lawyers in that situation would have to look out for themselves, right? And they would need their own lawyers, and they couldn't tell Karen Reed or Aiden Carney at that point what to do. So all of it just stinks to high hell, and it's completely unethical. There's no defense for this. There's literally nothing they can say that's going to make this okay.
And again, as Stephanie says, don't forget the judge allowed in the evidence of witness intimidation, which is mind-numbing.
Which was
itself. And
which
the
was
way she said it was like, if the witnesses, and she said this in open court, and she said this on the airwaves because we covered it was pre-trial. If the witnesses bring it up organically, it's coming in. So all the witnesses who were listening knew, well, I'm just going to bring it up organically, and then it's coming in, and they did. Jim
well, it's a
McCabe
mess.
did. Allie McCabe did.
It's a mess because
Colin Albert did.
at first the floodgates were opened with the daughter McCabe, Allie,
Yep.
who, if I recall, simply was being cross-examined about why she didn't mention that Colin Albert had been in the house in the first interview or whatever. And she said, well, that only became an issue later on. He hadn't been accused, which is a good answer, by the way. I mean, I think that's a totally, in my mind, credible enough answer that he was just nothing. And it didn't, if their position was he left and wasn't involved and didn't see anything, people could disagree about that. But how the judge determined that somehow opened the floodgates to allow all this evidence of harassment. And then once she allowed it, that's it. Then here come the other Alberts and McCabe's, and the floodgates are open. And of course, the risk is that the jury attaches the prejudice to Karen Reed, not other people.
Right.
So all of this is a mess, but it really goes back to why did the DA tell the judge that our belief is that the 4 of them or 5 of them, whatever it was, were conspiring? And this is after the judge was presumably aware of the search warrants for Karen's phones and whatever. And so in her mind, might she have thought, oh my God, they must have, evidence of something here. And if she had known that, no, what they had evidence was a pretty, a reporter who is, pounding the pavement repeatedly, trying to make a story, talking to sources who, in this case, just happen to be, a defendant and her lawyers, that somehow, without more, is a powerful reason to accuse somebody of witness tampering. I mean, this is crazy. Absolutely.
And they knew
after,
and they knew that there was no true bill. So they knew that Karen was not involved in it. And yet all this stuff was let in anyway. That had nothing to do with her.
Don't forget the timing of this too, which is another thing which I think people glance over. March 27th was just a couple of weeks before her trial. Mm-hmm. Okay. Now, everybody knows about indicting ham sandwiches and all that kind of thing. Yeah. So presumably the people actually indicting this are operating under the presumption will present the evidence. He's already under indictment for witness intimidation. She's already under indictment for murder. All the grand jurors know that the odds of an indictment are high. That's how they,
right, because the bar is so low.
In their warped mind, again, realizing they had no evidence other than phone calls and whatnot. But in their view, they think, well, we're going to get an indictment. So if they get an indictment in late March and there's supposed to be a trial that's going to start in a couple of weeks, there's a couple things that happen. Number one, there's a huge news cycle, right, that comes out. Karen Reed is facing new charges, which means the prospective jury pool who's going to get called to trial in a few weeks is getting, I mean, you think there's anything that could poison them. There's very few things that could poison them more than that. We're accusing her of this. And then, of course, you know how it works. The next application is, judge, put her in jail. Yep. And you put her in jail, and that prevents or creates a couple of other interesting things. Number one, again, I think in their sick and twisted analysis of how a case like this would work, they probably believe that would make her at least consider pleading guilty, because generally speaking, it's true. Leverage is everything. And when you're in the can with no end in sight, that does increase the likelihood of most defendants saying, well, if I'm going to be sitting in jail for this long anyway, and oh my God, let's work a deal and I'll get out quicker. Now, again, I think they would have or underestimated Karen Reed and her lawyer's resolve to say whatever. But, so if they put her in jail, they think that that's going to help them. But the other thing, by putting her in jail, up until then, they've seen the circus outside the courtroom. They've seen, whether people like it or not, the way she comes in to, a welcoming crowd and all of that. And that's just going to be much less, and the support is going to be much less if she's in the can. That's just the logistics of it all. So, don't underestimate the timing of this. They really did this as up to close as probably in their mind, thinking we can get an indictment and keep the trial date.
Yeah. Don't underestimate the supporters, though. I bet that if she was in the can, even more people would have showed up because they would have been even more outraged, I think. Ask three lawyers for an opinion, you're going to get three different opinions, right?
I think the optics are different, though, when she comes in. And, it's obviously, but yeah, no, I think the outrage would be incredible, but they just take away the visual of her entry and all of that. But the point is, getting this grand jury transcript now, only when this became recently a news cycle, because there was some dialogue in our case, frankly, about this, is odd. It's a good thing that he disclosed it, but why didn't Lally disclose it? And more importantly, more to the point, why didn't he make a fair and accurate, pardon that language, presentation of the fact pattern when he was advising the judge that he wanted to exclude someone from the courtroom? And you can't get over the fact that he went out of his way to say, we think that she and her lawyers and this journalist are conspiring to commit witness intimidation. And he absolutely 100% knew that there's no way. You don't think he's prosecuting a murder defendant? And I don't care that it was a special prosecutor. You don't think that the Norfolk DA's office is unaware that our murder indictment is presently being before a grand jury, by the way, with one of our key witnesses, Tully, and they're interviewing these people and they're reviewing Karen Reed's cell phones. You don't think Lally's going to be aware of what they find on her cell phone? I mean, if they found a confession on her phone that says, oh, by the way, I killed John O'Keefe, would he say, I don't want to know because this relates to witness intimidation and not my murder case? He knew. There's no way he didn't know. He knew.
Then he's in big trouble, if you ask me, because it's just
really up to her lawyers to make that an issue. I mean,
so Lally would know that there was no true bill returned, but Karen's lawyers would not know because that is a secret proceeding, correct?
Yeah. I mean,
they would not know. So it's not like the defense can be, well, they never asked for it.
I will presume they didn't know. I mean, on the other hand, there was a lot of publicity about when they seized her phones and, of course, because the way it works in Norfolk County, everybody leaks like a sieve. So it was public that, oh, they're investigating these two. And it's not inconceivable that her lawyers would ask the DA, what's going on? Is there anything we need to know? Now, what they were told, I wouldn't be privy to. But I don't think they knew, but I don't know that. But on the other hand, what I do know is that they never made a stink per se when that motion was filed, in which their client and themselves were accused conspiring in a 4-person conspiracy with Aiden. And you can be sure that if they knew that a grand jury had rejected that, they might have had something to say.
Oh, absolutely.
So just using common sense and context clues, I'm going to imagine they probably didn't know what was going on.
Neither Jackson nor Yannetti have known to, not speak out when they disagree with something in front of Judge Cannoni.
Well, I think by the court's own admission, neither one is a shrinking violet or something.
Shrinking violet, right?
Isn't that what she said they were?
I think you're right. Here's number 15, a copy of an updated Celebrite report of the web history regarding Jennifer McCabe's phone. This report was just run on September 17th of 2024 on Celebrite version number 7.68. It's a 77-page report. I'm assuming this is the new version of Celebrite that is going to now all of a sudden say the 227 search was not really a 227.
I don't know what it's going to say. I assume that's what they're going to say. It makes sense to me scientifically if the software gets better over time, that if you analyze it now as opposed to then with more recent software, you get a more reliable result. But of course, it comes down to chain of custody, who had the phone, whether anybody was, diddling the phone beforehand or not. And, so whatever the report says, I don't think you can just dismiss out of hand. Like if they come in and say, look, it shows it was at 6 o'clock or 6:20 or whatever it was, that's part of the issue. But the next part of the issue is, how do we demonstrate that nobody had access to touching the phone and making any kind of manual things? I mean, there was evidence in the case, as you know, that didn't Karen Reed's phone go on or off when it was in police custody at a time when it shouldn't have been? Maybe I'm conflating this with something else, but
I don't remember that.
I don't necessarily think this is a bad move. I mean, if the guy is truly, on the one hand, when he made his statement coming in and he said, we'll do this fairly and properly, and it sounds great, that's fine.
Right.
I don't think you should assume that Hank Brennan is not fair. I think it's fair to question why someone like him would take this. That's for consideration. But I don't think you can assume that because he was Whitey Bulger's lawyer that he somehow, is a bad guy or anything like that. I have never met him. I don't know anything about him. So I'll give him the benefit of the doubt that he's trying to be, straight down the middle on this. The only problem is when you look at some of the language in the other motion about the telematics that we saw.
Yeah, we'll get to that next.
At the very end, when it says it, in conclusory terms, it talks about how Karen Reed, ran over and killed John Keefe, which means, all right, I guess we're not doing this fully down the middle, maybe like 3/4 of the way, because I'm still, even though I'm following the evidence and I'm trying to be open-minded, I'm still stating, she absolutely with certainty killed him by running him over. So, that it's kind of an inconsistent messaging here going on.
Yeah. And it's also important to point out that they have to turn this stuff over, whether they're going to use it at trial or not, and whether it's exculpatory or not. I mean, so it may just be that all of a sudden, listen, if they've got a new version to celebrate, are all of those deleted calls now going to come up? And all those deleted messages and all those deleted, screenshots. So, but we can't necessarily assume that it's not going to be helpful to the defense just because it's listed here.
No, and I think that there's a lot of breadcrumbs in here, and this one is another example of that. This guy, understandably, in my view, if possible, does not want to touch Guarino or put him within 8 miles of the witness stand. Now, is that possible? I don't know, but he testified about some of the McCabe stuff too. And if you're trying to erase him from the process as much as you can, then you need to have, again, your people do it their way as if it hadn't happened in the past. Now, they can't erase the past. That's the problem. They're going to, when they start calling all these experts, that doesn't make Trooper Paul, it doesn't mean he goes down the memory hole like in 1984. I mean, I'm sure the defense is going to want to have a wonderful time talking about the materials that the new expert reviewed, and whether that includes, the excellent opinion of Trooper Paul and his analysis about this, and whether he agrees or disagrees with that, and how he got to where he did, and da 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 da.
Well, first of all, I'm just noticing that it just says web history. It doesn't say call history. It's just web history about Jennifer McCabe. And then the next thing is the Birchmore materials, and that's where we get to Guarino, because he did not find 32,000 messages on Farwell's phone between Farwell and Sandra Birchmore. That all that stuff was on her laptop. So there goes his credibility. And that's,
well, also it's a lot, because as you look at this list and you see 3 pages, 2 pages, 1 page, and then here you have 1 flash drive, which is, that means it's a lot of stuff, and so it's a lot. Yeah.
And then we've got Brian Tully's CV for whatever reason. And then we get into the extrapolation stuff. So now we've got Massachusetts State Police Crime Lab Forensic Services Division Serum Conversion Factor Update Memo. It doesn't have a date on it. And so I'm curious about that. Are they now going to try some new theory on the serum conversion factor extrapolation blood alcohol content stuff?
Don't know what else this could possibly relate to, other than trying to firm up the extrapolation and all that. But they have a non-scientific problem with their scientific analysis. Anything to do with extrapolating her blood alcohol content, which is, and everybody knows this, and you don't have to know science to know this, that any scientific opinion or test, there are certain conditions precedent that have to be established, that have to be reliable. And any scientist will tell you that if those conditions precedent are not reliable, then the whole thing goes out the door and I can't give you a solid opinion. And when you're trying to extrapolate blood alcohol, content over the course of a certain time, you need to know when the last time alcohol entered the equation. And that's, they don't have that except through Michael Proctor.
Mm-hmm.
So all of this blood alcohol stuff is ultimately going to come down to him. And if his testimony over, the last time that she drank was this time because that's what she told me, that's not good for them. And I understand what they're trying to do, but this doesn't solve that problem.
Yeah, because Jen McCabe testified that Proctor wrote down the wrong stuff in his report because she never said that. And that's what he wrote, but I never said that. So the reliability of Proctor's reports is, obviously he's
that's something I think also
on unpaid leave
on a second trial that I assume they'll kind of pay more attention to, are all of the inconsistencies that come in all of these police reports. And, whether you blame the witness or whether you blame the recording witness, the Proctor, the Buchanan, or whoever, not all of that, none of that is good for, the prosecution. When you have, for example, McCabe saying, I don't care what he wrote, this is what I said. I mean, I would think that, that's worth probably, never mind the hour limits in a summation. I'm assuming that'll probably change in the next trial. I believe that will change.
I believe a lot of things are going to change if it happens.
Now, you never want to use too much time, but I think that will change. But my point is, Jen McCabe's curious and evolving story, which gets more curiouser and curiouser as the night goes on and the days go on, that's probably worth a good half hour alone, especially when, I hit him is apparently, their view of the key fact. I mean, to me,
confession. Yeah.
And if I'm the prosecutor, that's kind of a backup fact that adds a little flavor to the main part of the meal, which has to be like the real evidence, not, Karen's belief, even if you believe what is being reported that she did it. But if their key evidence is I hit him in the state of mind that she was in and the ARCA evidence and all that, they're never going to get past the finish line. But it'll be even worse if the defense at the next trial, if there is a next trial, focuses on really drilling down on how her story just makes no sense. And that, I assume, look, if Proctor, maybe it gets a little trickier if Proctor's not around, this may be even a reason they have to call Proctor if you're the defense. Because Proctor, if he's called as a defense witness, like every police officer, whatever he wrote, it's fact. That's it. Like, they don't deviate. He's not going to get up there and say, yeah, you're right, I made that up because I wanted to, make this a bad case. So if Jen McCabe sticks to her story that, I said this from day one, then I would assume there's a good chance the defense will call Proctor to impeach her for the even for no other purpose than to just talk about the report he took and that he was careful and accurate, and your buddy Yuri was with you the whole time, and this is what you wrote and that's what she said, right? And he's going to say, and then the question is, what's going on here?
Well, what's interesting too is that your trial for Aidan Carney is supposed to happen sooner than this retrial, correct? Just hypothetically. Scheduled to happen in December, yeah?
It is.
And in that case where he's accused of or charged with witness intimidation of all of these people, Jen McCabe, Matt Proctor, all of these people, Buchanan, they, I am assuming, will have to testify in that trial, because who else is going to testify about how they were intimidated except for these witnesses themselves? Yes.
Well, yeah. I mean, anyone who is an alleged victim of suffering emotional harm from witness intimidation will have to testify at trial. I mean, Massachusetts in a grand jury allows hearsay, unlike New York. So they don't necessarily have to, although they may testify about all of that stuff. But in order for the indictment to survive, if you will, they would all have to testify. Now, that case, by the way, though, is not scheduled before.
It's not scheduled for December. That's a different case?
At the present time,
okay.
The case that is scheduled for trial is in the Dedham District Court, which relates to the February 26th court appearance and the allegation of the violation of a restraining order by, being kicked out of the courtroom and then not leaving the court area as was outside.
Yes.
But yes, at some point, those people, all of them, would have to testify, including Michael Proctor. He's a named victim in the case, including Buchanan,
Yuri Buchanan, right? Jennifer McCabe,
Brian
Albert, Colin Albert, Chris Albert.
It's all of them. I mean, it's the people, the named people in the indictment. I mean, you've heard of them all. Let's just
and just so that all of our non-lawyers in the chat know, all of that, anything that they testify to in any other proceeding is fair game for you to impeach them in your case, just as if they were to testify before the Karen Read trial. In your case, all of that testimony sworn to under oath would be able to be used in another proceeding.
Credibility is always relevant. Yeah.
And this, as far as the serum conversion factor stuff, extrapolate, we don't know if she went back to John's house and drank a bottle of vodka. Like, it's just
I find all of the blood alcohol stuff just not going to be very impressive based on the basic fact that the only evidence as it stands right now to use the extrapolation, you need the time. In order to extrapolate the time, you need a beginning time and an end time. And that comes from Michael Proctor, who, as I said somewhere else the other day, I mean, if he told you today was Sunday at 4:54 p.m., I would say you can believe him, but only if you look at your watch and confirm, because anything somebody like that tells you without corroboration is probably not worthy of belief for a number of reasons. So if he's the only source of that, how reliable is it if A, it's coming from him, and B, what's he basing that on? That's what she told me. Okay. Yeah. I mean, that's just not impressive evidence. That's all. It is what it is. So I don't blame, Hank Brennan for getting a better scientific analysis of what he believes the evidence is based upon the time that she stopped drinking. But even if he shows that, scientifically, if you stop drinking at this point in time, this is what your blood alcohol would be, that's great. If the time is accurate and reliable, it's not. So the science becomes pointless.
Exactly. And even their own witnesses testified to that at the trial. So new trial, new motions in limine, right? New motions in limine. There can be another motion to exclude all of this stuff all over again.
Well, certainly. I mean, they're attempting to do other things. The defense has a right to try to block them from doing other things.
Absolutely. So if by chance, let's say it goes to another judge, which you never know what could happen. There could be another judge ruling on all of this stuff. I don't know. Somebody asked, could there possibly be a reason to exclude her, to get this case assigned to another judge? Do you think Karen has grounds to request a new judge?
You're not getting a new judge on the basis of, Your Honor, we think you're biased. That's not going to work. Even though there are reasons, I understand why people would say, but it's so obvious. But who's determining that motion? Judge Canone. It's in front of her.
Ridiculous system, right?
It is. And there's always, lawyers think about these motions from time to time. But then you also think about, what if I make that motion and the likelihood is I'm going to lose? And then you sit there and you say, well, now it's real bad.
They tried it.
It becomes real bad. And I see somebody, I'm just glancing at the comment thing. Somebody says a bench trial. I've always said this is a great bench trial, not in front of this judge particularly. But on your hypothetical, if there were another judge, depending on who that judge is, and you'd have to do your homework. There's clearly reasonable doubt, and when you go online and you see the Twitter nonsense and the screaming back and forth about she's guilty as hell, she's innocent as hell, this that. As lawyers, you sit there and you say none of that even matters. Just as a legal exercise, there either is or there is not proof beyond a reasonable doubt, and that's different than innocent or did it. I believe she's actually innocent. That's my personal, based on what I know and what I've seen. But as a legal exercise, the evidence of reasonable doubt appears to be overwhelming, whether you think she factually did something that's illegal. So a judge understands that. A judge who's judging fairly, sees the scientific evidence from the accident reconstruction people, sees the other evidence, sees the credibility problems. To me, it's pretty open and shut as a legal exercise.
Right. Agreed. All right, moving on from the serum factor conversion factor update memo. We've got a police report regarding complaint investigation, something in 2019, 4 pages. No idea what that is.
Well, that's interesting. I don't know if that relates to some kind of disciplinary thing. I don't know. I don't know a complaint unless that's
Seems
just
like it's.
It appears to be from, I'm assuming, 2019. I don't know. I don't know what the H means. I don't know what their system is, but obviously the lawyers who received this will know and
Yeah, because it'll have exhibits attached to it, which we don't have.
4 pages of something, apparently.
Yeah. Copy of Departments of State Police Personnel Order 9/23/24. No idea.
Well, this is another typo date, which is interesting, and
9/23/4. Yeah.
They've had. We all make typos, and you always find it like after you submit something. But it's just the nature of legal writing. But there's been a lot of typos in dates of things, which that's not a criticism as much as wondering when you saw January 1st related to the Sallyport video, is that a typo? Or, I don't know, because a lot of it appears in dates.
Right. This could be 2014. It could be 2024. It could be 2004. We don't know. Here's another copy of Massachusetts State Police Division of Standards and Trainings, OPIA, Internal Affairs Report, dated 7/29/24.
Well, that's probably going to relate to the usual suspects in this. Everybody knows it's not an issue that at least 3 of these guys were actually 4, because Fanning was under investigation but was unsubstantiated, which is not the same as exonerated, by the way. But there was no actionable proof to act against him. But between him and Proctor, Buchanan, and Tully, I'm sure that's what this relates to.
Right, one of them. Thanks, Mike, for pointing out Troop H is Troop H of the MSP, which the Norfolk troopers are a part of. Thanks for the deets on that.
Interesting. That could be Giglio material. That could be somebody complaining against one of these guys. And Brennan, of course, who comes from a defense background, recognizing, unlike perhaps people in the DA's office, what may be considered favorable or not, may be disclosing an allegation against one or more of these guys from a 2019 case. And maybe I'm speculating here.
Right.
Does it relate to false testimony? Does it relate to lying? Does it relate to bad phone extraction? Does it relate to not being polite? I don't know, but this is interesting. If this is something to do with that, that would be very interesting. But we don't know.
We don't know. Here's another internal affairs investigation report dated 7/17/24. Probably the findings relating to one of those, maybe Fanning, because he's the only one that they've said is concluded, right? As far as I know.
It's dated in July, which is it may even just be I don't know. I think it clearly relates to one or more of these guys. It's pretty close in time to the trial ending. Maybe it's just something saying, you got to put these knuckleheads under investigation based on what happened in the trial. Um, it says findings though, which
Yeah,
is interesting, and that's really early. But the Fanning news didn't come out for months, if that's the case. So I don't know.
that was right after the mistrial, which was around about July 1st-ish.
Right.
So that's interesting. Okay, a copy of the CV of Judson B. Welcher. Judson Welcher is a biomechanical engineer and accident reconstructionist.
Oh,
He happens to work at the same firm that the next person that we're going to read about in the next motion about the telematics works at, which is called Aperture LLC. He's a biomechanical engineer and accident reconstructionist, and he's been one since about 1994. So he's got a lot of experience. And this indicates to me that they are steering away from Trooper Paul for this trial.
well, good. I mean, let's be fair to the let's be fair to the process again.
Yes, agreed.
Brennan is a real lawyer, obviously. I mean, he's tried big cases. He clearly is experienced. He's a former prosecutor. Frankly, probably from a better DA's office than the Norfolk DA's office, I'm assuming, at Essex County in North Shore, whatever. And I don't think it takes a genius to recognize when you come in with a fresh set of eyes that we can't have that. I mean, that was
Right.
embarrassing. But also, you can't have an expert who happens to be from the state police whose source of training is, I took a couple of math classes. I mean, that just doesn't, that's not expertise. That's like getting a certificate in nothing. So, I mean, that you'd expect this. I mean, that's why they're going to the bullpen across the board. I think they are trying to, again, de-ice all of this from involving the Massachusetts State Police whenever they can. And Paul is the obvious one. I mean, clearly. And Proctor, easy.
These next police reports, this case number 2022-1112-33, this is the John O'Keefe case number. I compared it with the documents that I already have, but I don't know. This is report number 100, 101, 102, 103.
Well, it could be Paul's reports. Now, if that's the case, why weren't those disclosed previously? That would be extraordinarily troubling and absolutely a discovery violation and even possibly a Brady violation. So we don't know what it is, and I don't want to speculate. But
look at the dates on them. They're all new dates, dated 9/27/24, 9/30/24, 10/2/24, 10/2/24.
It could be just internal stuff, talking about investigative steps, about getting ready to do testing. Went to 34 Fairview Road and kind of mapped it out and looked at this, and he gets documented in a report. I mean, that's going to have to be disclosed. So it could be
new.
Well, yeah. Well, again, you get a real expert. No real expert is relying on what Trooper Paul's not real expert opinion was. They're going to, I mean, I don't think any expert worth their salt would say, I'm just going to look at his report and say he's wrong, but here's what it's right. You can dismiss him easily, but you need to say, I need to look at the place. I need to look at the equations. I need to look at this and tell you, and I need to be able to testify that I did it on my own, which is probably what this is.
And there was some rumblings of Yuri Buchanek being in the area as of One Meadows. And here's a new Ring video of One Meadows Avenue on October 1st of 2024. I'm curious about that. In addition to the copy of photographs of cars from John O'Keefe's report. And again, this is report number 101. So this must be report number 101 up here. They went and photographed the cars. This must be the report of what they did on 9/30 of 24. And then here's the photographs of the cars from that report on a flash drive.
I'm going to assume that there's a lot of cars, but I think also, again, you're bringing in somebody who thinks a little defense oriented, a little more experienced, better at trying cases, and probably a little better at chess than the prior prosecutor and looking ahead. And would any of us be surprised if some of this is going to relate to John O'Keefe's car, and they're going to try to proactively nip in the bud what they will try to argue that there's no way in hell that the the ding on Karen Reed's car could have come from bumping John O'Keefe's car. So I wouldn't be surprised if part of that is part of what these reports are from the photographs of cars from way back when. And for all you know, they may, you say copy a ring video at One Meadows. Would any of us be surprised if they tried to recreate that accident? Okay. And same view from the same camera. Okay.
Right.
So you get the same make, same model, you go the same speed, you get the camera to pick it up. And what does the camera show? And then what is the damage to the cars? And they try to say, well, see, we recreated this and there's no damage. So therefore, common sense tells us that it couldn't have happened there.
And that makes sense because Welcher's CV is, I mean, if we're going to say this is in any sort of chronological, logical order, which it seems that it is, he's the one who's going to testify as to the accident reconstruction of what happened in the driveway of One Meadows early in the morning between Karen's vehicle and John's vehicle.
And if you're going to do it, you're going to do it under, as best you can, the same conditions. Obviously, you can't get the same weather conditions and all of that.
We know it was snowing.
I assume, well, you certainly know that. But I would assume that they would, as best they could, take the car that is the same make and model as John O'Keefe's and put it in that exact spot, and take the SUV that is the same make and model, get the ring camera in the same location, and say go and let's see what happens.
Mm-hmm.
This is all speculation. We don't know this, but that makes perfect sense to me. If I'm coming in, if you said, how would you retry this if you were them? And my first response would be, I wouldn't, because I don't think it should. But if I was, I would want to satisfy myself that I have an answer for that, because they had no answer for that.
Correct. And they have another report, number 103. And then there's a copy of Massachusetts State Police Case Master Report. This is a different report number. So it's something that happened in 2024. And there's a bunch of reports, an administrative report, another administrative report, all
These
with the same
after the trial. So I don't know if this relates to personnel, if this is more personnel stuff. I mean, it's administrative, it says. So I don't know.
I don't know either going on. So there's a lot of case master reports. And then here's another one from July 9th of 2024, another report. CITI is in the title there. If any of you know, please help us out here. 2024. Again, CITI-88. So this is all a whole other case. And then again, Massachusetts State Police administrative logs. This is all relating to other cases that we don't know what they are. I don't anyway. July 10th of 2024.
I mean, you don't know. This could be related to Proctor's phones and evaluate, if after they started looking at to see if he said things in other cases. I mean, again, total speculation, but around the timeline kind of fits. It's after the trial. It's after he started an investigation into him. And I don't think it takes a genius to at least wonder if anyone would want to look and see if Proctor on other cases had, looked for nudes or said anything similar and offensive or certainly compromising to his own credibility. And maybe these are some degree of evaluations of other cases. I mean, at some point you'll find out, but I don't know.
And here's a property release report. And there's more administrative log reports that we just could speculate about, but there's really no point. Here's a copy of the Massachusetts State Police Office of Professional Integrity and Accountability report dated September 30th of 2024.
When did the report come out that Buchanan got his wrist whacked with a ruler and lost 5 days on the back end that he'll never lose because he probably has 800 days? I wonder, and again, I don't know the exact timeline, but if this, that could be that.
That could be that, yeah. And then we have the copy of the Canton Police Department incident report. That's the 36-page rubber ducky report involving Richard Schiffer. So they're turning that over for whatever reason.
Isn't it amazing what takes up 36 pages and what takes up 1, 2, and 3?
Wow. It's like 33 more pages than the investigation of Officer John O'Keefe got. Here's the CV of Hannah Knowles. I think I looked her up too. Let's just see. Hannah Knowles is with the Commonwealth of Massachusetts. She's a forensic scientist there, and she's been there for, well, she's in the toxicology unit. She's been there since 2006. So she too has been there for about 18 years, but they didn't use her in the first trial. And then again, this is going to go with the blood alcohol extrapolation, serum conversion. And so they're issuing new reports. It's like they're doing it all over again.
Yep.
More extrapolation reports and XOXO, Hank Brennan.
Now, this is interesting.
Mhm.
On the signature page, it's just him.
Yes.
You know, some of the other documents you see, although he signs it, you know, they include their whole team. This one doesn't. It's just him. Again, does that mean anything? Not necessarily, but you know, it's disclosure of evidence, some of which I think we all agree at least should have been disclosed previously, and they've decided to take the others' names off of the signature line. That's interesting.
Yeah, very interesting. Lisa says they feel like they're trying to exonerate the witnesses, Higgins, etc. I'm playing defense again. I don't know. Maybe.
Well, if Higgins was, you know, again playing like crash cars, doing wheelies, drunk in the parking lot at 1 a.m. in the police department, from the prosecution's perspective, that's good because that's what he said. So I mean, they're trying to see and presumably turning over video of the time frame when he says they went there. What's interesting is you don't see any other attempts to, you know, fix library video or, you know, maybe ring video, which disappeared, that might have shown something more. But again, you can only fix what you can fix. So
well, we saw the clarification reports, if that's what that means. Hi, Jen Altman. Thanks for the 10. Framingham South reunion again, she says.
Yep.
Thanks, Jen. Somebody said you're looking hot today. Look at that. The EC35 Bederow is looking hot. As always, we love you, Law Daddy. Thanks.
Sunday slob, Sunday football slob. I'd rather be like this 7 days a week if I could.
I know, right? No more suits and ties. The Diplomatic Diva, thank you for your super sticker. Wondering from the UK, JN Books, wondering if the defense can call Procter and Company if the Commonwealth doesn't. Also, would they?
They might. Again, as we said earlier, if I mean, Jennifer McCabe's not going to change her ludicrous story. I mean, it's her story, and she's got no choice but to stick with it.
To it, yeah.
Has to. I mean, she left no wiggle room. I mean, she was adamant that I was consistent in always saying that, you know, she said, Karen, I hit him. So Proctor is one of the witnesses who can debunk that, if you will, based on what he wrote down. I mean, it's obvious. I mean, look, Proctor testified in the first case that after I spoke to Jennifer McCabe and did a few other things, including seeing a, you know, man with no coat lying in the middle of the lawn with one shoe, that this clearly had all the indicia of a hit and run. Now, putting aside the absurdity of that, the point is he said that was good for him to go down, order up a tow truck, and here we go. So knowing that he had such tunnel vision, correct, of course, in his mind, in this uncompromised investigation to make a proper arrest, wouldn't he have said in defending himself at the first trial that one of the analytical data points that I used to reach that conclusion was because the minute I spoke to these people, including Jennifer McCabe, she ran up to me and said, "Oh my God, Karen Reed said, I hit him. But he didn't.
Right.
He didn't because she didn't tell him, because he would have written that. And I think both sides would be stuck acknowledging that. And if you don't acknowledge that, if you're Brennan, now you have to get into the, you know, hold your nose, get out your Lysol and say, well, you know, Proctor's kind of a, you know, scummy, unreliable, and, you know, I'm kind of admitting that maybe he did do a little bit of a, you know, fudgy report. But why would he do that? Why would he lessen the report, it doesn't make any sense.
No, and why would they let her leave the scene?
No.
And then section her. Like the whole thing just strains credulity.
No, it does.
Let's take a look at the motion for the telematics system, because this is interesting, and I'm going to be interested to see how they do this. Because after we go through this, I want you to watch a little bit with me of the Guarino testimony.
Before you put this up, so when
Yeah.
this got teased online in this ominous manner a day or two ago.
Oh, with the order, the proposed order.
But well, that's the keyword, proposed, and this is the
it's not an order.
problem when you rely on Twitter as your legal source for how things work and what impact they have. Okay, a proposed order is, as Melanie said, proposed. We would like Your Honor to sign this.
Yeah.
She had not. Also, you have to bear in mind that the way it works, who drafts the prepared order? The person who wants said order. So the judge may very well sign it. She probably will. But to jump up and down the other day by showing a proposed order and not even the motion and affidavit that supported it, and not having a signed order for the motion saying that's it, it's over.
Well, here's the thing too. The defense has the opportunity to oppose the motion.
Absolutely.
And they oppose the it's not just like an ex parte thing that's just going to be granted. The defense now gets the opportunity to oppose this. They're asking for a hearing in the motion, so there needs to be a hearing. And really, a proposed order is like sometimes what a lazy judge will do will be like, all right, settle order on notice. And they'll be like, I'm not writing the order, you write the order. So they're trying to help the judge out by cutting corners and being like, here you go. That's all that was.
I don't want to jump ahead too much, but just again, because online people go crazy. The proposed order and the prosecution is admitting the right thing to do here is to give the defense the opportunity to observe the process with their own expert to keep this even-handed. So there is no information that has yet been taken. There is simply their new expert, because Guarino is, not up to the task, apparently. That's what they're saying here, basically.
I know.
And that's a big deal, because they're going to have to deal with that as well, is simply saying, I think we can get data. Okay, maybe you're right, maybe you're not. But how that turned into a breaking news smoking gun, maybe in the attic, but elsewhere, it's not.
Yeah.
This is
lawyers know. If you know, you know. If you don't, you just assume that this is like it's blank. I'm just going to pull it up just for fun because
it's a good move by a new prosecutor trying to, as best he can determine, find the evidence. I don't know what the evidence is going to show. It's the right move, but this is not some smoking gun breaking news, she's screwed development.
Here's what it is. It's a proposed order. It's unsigned. It's undated. It's pretty much nothing. See,
I could literally prepare this
order.
If you gave me 5 minutes, I could prepare this in the same font and same spacing and send it to you and post it, and it would look just like that. Because what's missing is, the date and signature and all the other stuff that goes with it. So
yeah. I thought it was so funny. And then, Coffin offers out there like, look, they've ordered a new thing. Like, no, that's not what that means. And so I think it's kind of funny that, people who aren't lawyers get out there and start hypothesizing, or actually not even hypothesizing, saying emphatically that this is what this is, and it's not.
God. Yeah, no, it's silly. It's just silly.
Mm-hmm. Well, crazy's gonna crazy.
We're all here for the silly, yeah.
Yeah, pretty much. It seems that way. All right, so here's what they want to do. This is paper number 392. This is the Commonwealth's Notice of Scheduling, Reassembly, and Testing of Defendant's Lexus Telematics System. So they want to bring a new expert in. His name is, where's his name? I have it over here. Shannon Burgess. In the above caption matter. Here comes the Commonwealth. Now comes the Commonwealth through its expert, Shannon Burgess, in the above caption matter, and respectfully provides notice to the defense and this honorable court that it intends to engage in further testing of the defendant's Lexus telematics system. Mr. Burgess has opined that significant data was likely not acquired during the chip-off procedure, likely caused by by programmer's error. Programmer is a technical term referring to hardware and software utilized to acquire and interpret data, which says see October 10th letter from Shannon Burgess as Exhibit B.
You could stop right here, and in one paragraph, if we translate this to English, they're saying we don't trust Guarino.
Exactly.
I mean,
we got somebody better.
They're saying this guy's a problem for us. We need better.
We need better. We need better. And here's what we want. Here's what happened. The infotainment and telematics modules were seized pursuant to a search warrant on February 2nd, 2022, which coincidentally is the same day that Karen Read was arraigned on these charges in court. That's when they got their search warrant. And then on November 30th of 2023, like this is what's mind-numbing to me. They didn't even start looking for this stuff really until November of 2023. Or they had it for a long time. They never really tested it. It was just, and then on November of 2023, this court, without objection from the defendant, allowed the Commonwealth's motion to permit destructive testing of the infotainment and telematics system due to the means and methods required to retrieve this vehicle's data. December 1st, 2023, the defense expert Maggie Gaffney performed a procedure known as a chip-off, a digital data extraction and analysis technique that involved physically removing memory chips from the Lexus's infotainment and telematics system. So this is like December 1st of 20. Remember, this trial was originally supposed to start in March. So this is within 90 days of trial. They're doing this, finally. Involved physically removing memory chips from the Lexus's infotainment and telematics system. This procedure was observed by Trooper Nicholas Guarino and the Commonwealth's expert, AG Speak, who authored a report detailing the process and his findings. Well, he was never called as a witness. Speak. See Exhibit C. While a chip-off had the potential to be destructive due to the technique required to remove the chips, in this case, the memory chips associated with the infotainment and telematics module from the defendant's Lexus were not destroyed and have, along with the infotainment system, telematics system, and the Lexus vehicle, remained secured in evidence. Sure. Mr. Burgess, through his training and experience, believes the evidence acquired in the chip-off was incomplete and that more data that was not acquired exists on the chips. Hardware and software updates have been developed since December of 2023, including but not limited to an updated version of Berla's IVE software. These updates were not available at the time of the original testing. The likely deficiencies from the original testing involve two modules in the vehicle that have the capability to store data, an infotainment module and a telematics module. The infotainment module, MMU, includes a built-in diagnostic recorder designed to capture vehicle operational logs. If a vehicle is equipped with navigation, the system can also record geolocation data in the form of track logs. And that says Lexus infotainment system first had a native navigation application in 1998. The telematics module, DCM, also has the capability to store track logs. Navigation events can be inferred from the start and stop points of time-based tracking. In addition, the modules may contain device connections to the vehicle and separately Wi-Fi connections to the module obtained and stored as the vehicle travels. Mr. Burgess identified that two potential data-bearing components were removed from the MMU and identified a 64 megabyte flash memory component and a 16 megabyte EEPROM. The file readings resulted in 3 files, 8 megabytes in size. Mr. Burgess opines that the acquisition of files in December 2023 should have been closer to 64 megabytes, believing that the discrepancy likely resulted from deficiencies in the hardware and software used at that time to interpret the data. Mr. Burgess determined that 3 potential data-bearing components were removed from the DCM. Similarly, Mr. Burgess identified that 2 of the components, Micron JWB57 and Micron, lots of long numbers, likely contained incomplete data acquisition, likely resulting from the hardware and software used at that time.
A lot of likely without explaining why it's likely.
Likely. So here, 5 megabytes and megabytes and more megabytes and gigabytes. Based on these likely deficiencies in acquisition, Mr. Burgess has recommended a review of the chips that have previously been removed, and subsequently a reattachment of the chips to the board in the defendant's vehicles. Mr. Burgess would employ updated programming and current software versions to maximize the chances of a complete acquisition. Mr. Burgess believes the use of a variety of different hardware programs and updated software will yield a more fulsome acquisition of data. When's the last time you heard that word, fulsome? Mr. Burgess has provided a detailed outline of the procedures and efforts he would employ. See Exhibit B. Given that the testing is potentially destructive, the Commonwealth is providing formal notice to the defense and an opportunity for the defense to employ its own expert to be present during the different stages of further testing. The first stage of testing would occur in Texas, and the subsequent testing procedures would continue in Massachusetts. The testing is necessary and could produce relevant and material corroborating evidence for trial. This evidence may be exculpatory or inculpatory. Track logs are essentially an ordered sequence of GPS coordinate measurements stored by a satellite navigation system. Unlike telephone satellite data that are employed in triangulation analysis to place a cell phone in a general area, track logs provide specificity. So, what we told you before, with regard to the cell phone data and all that is not really very accurate, which means what? Oh, maybe John O'Keefe did go in the house. In my mind, I'm using that to my advantage. Generally,
even when if this is all true and they can put this back together and the car shows you it went from here to here, from there to there, that's still not going to help them, exclude John O'Keefe from the house.
Exactly. But they're again trying to prove that Jen McCabe was telling the truth when the car moved up and up and up.
They're not going to be able to put him. Well, let me back up. They're not going to be able to say, based on what they are proposing here, that he was or was not in the house because this is just the car. Yet this expert presumably is going to kneecap Guarino's opinion and the analysis that he gave to say why, in the first case, he could not have gone in the house and did not, in fact, go in the house.
Right, because when you're in your car, it logs steps, but it's not really steps. And if you're going up and down steps, it could just be that you went over a hill.
I don't know that this is a net gain when you weigh the pros and cons. But, again, if you take him at face value, he wants a real expert, and he's saying we have to do real examinations, and he's giving the defense notice to be there. Although, by the way, send someone to Texas, which is lovely. But,
right.
I guess I don't know what this is going to do to move.
Well, here's what they want to do. It says this information is tantamount to laying down a breadcrumb trail, memorializing travel by location and time. And then they say that it could potentially, find out where she went before, at the time, and after the defendant's Lexus was involved in a triggering event. Here's what he says. In the case at bar, track log information is significant. If track log and other various data information exists, it will serve many important functions. The benefit includes corroborating the defendant's travels before, at the time, and after the defendant's Lexus vehicle was involved in a triggering event. If track log and Wi-Fi information is retrievable, the data would provide independent corroboration to the numerous witnesses who made observations that the defendant's Lexus was parked in front of the Fairview Road address after midnight. Further, the data would identify the location of the defendant's vehicle at the time it engaged in the impact event and provide the time and location of the defendant's travel from the scene to the location of Mr. O'Keefe's home.
Okay. Again, the cost benefit of this, I applaud them for wanting to do this, but there's a hell of a lot of supposition here. And, there is certainly a chance that this isn't going to come out the way that they hope it does.
Yeah. And here they say the Commonwealth provided and introduced a trial video depicting some of the defendant's travels on January 29th of 2022. The additional data likely to be retrievable, again, likely, would assist in identifying the precise locations that the defendant's Lexus traveled from the time that the defendant struck and killed Mr. John O'Keefe until the time the vehicle was seized. So again, we're likely supposing she actually struck and killed him.
That's where, it's this one sentence which, again, to me, throws this all sideways, because there is every indicia here of reevaluating this. But if you are reevaluating this with a conclusion already set and trying to find facts to support a conclusion that you've already made, then it's a flawed exercise. I mean, it's like trying to jam the square peg in the round hole, hoping it fits. So the statement that was made at the beginning and all of this, it's all lovely. But if you've literally concluded that she had to have done this when you're saying we need this evidence to determine whether she did it, that's inconsistent to me.
When you're a hammer, everything looks like a nail.
Yep.
Commonwealth respectfully requests a hearing within the next 14 days to permit prompt testing and production of relevant discovery, whereas this matter is scheduled for jury trial in January 24. Oh, but look, XOXO, Hank Brennan, but he puts Adam Lally and Laura McLaughlin on here as well.
Well, this is interesting, but Lally does not sign it. So he is, in theory, not subject to owning this.
Yeah.
Is this a sworn statement? I mean, I know Massachusetts has a really bizarre, I mean, I shouldn't say bizarre, it's different than New York. I mean, in New York, you would submit an affirmation and a memo of law, whatever. But
Or
is this
verification?
a sworn,
yeah.
Is this a sworn state? Norfolk SS.
I mean, it's really just a notice of scheduling. It's not even a motion to say, can we do it? It's just like, here's what we're doing, like it or not. If you want to come to Texas and pay another expert $1 bazillion and travel and everything else to come and do it. It's just another cost for the defense. Right? I mean,
yeah,
it's kind of like, we're doing it. You can have a hearing if you want, but this is what we intend to do. And here's Shannon Burgess, which I thought this was interesting. His LinkedIn profile indicates that he is, get this, folks, he's a mystery solver. He's a mystery solver. That's what he's going to need to do. He's a hardware hacker and a mystery solver, because this is quite the mystery.
Yeah, that's regrettable phraseology.
So there he is. And we also found out that he seems to be friends with Jessica Hyde. So that's interesting. That, they're connected somehow. Perhaps Jessica Hyde actually recommended him to the Commonwealth. It could be.
I mean, that is a lot of times how the real world works.
Yeah.
As opposed to at the first trial when we were so surprised that the way they found their non-MSP experts was by Tully sending out cold call phone calls and emails, like hitting the contact us email to these random people and saying, how much to do this. That's not what you would expect, the Massachusetts State Police and how to get an expert. I mean, the interesting thing is, and they couldn't do it in this case, a lot of times you might think that a government agency who needs help with technological data would turn to somebody else, something called the Federal Bureau of Investigation, for help.
Right.
But
right.
Clearly there may have been a potential conflict here, given that the FBI was already involved in this, looking at it through a different lens. But I mean, I don't think it's disqualifying that these people are friends or whatnot. It's odd. It's probably not ideal. The same way calling yourself a mystery solver is probably not ideal. I don't know that that's the kind of thing that I would get into, but it's a huge case, and
it's definitely a mystery to me.
Oh, maybe they'll all show up in the mystery machine. Who knows? But they need people who are really good at what they do. And I don't know if that's him or not, but the disadvantage they're working with is that, ARCA, those guys are, top level at all of this accident reconstruction stuff. And if they're bringing in this forensic guy along with the accident people, it really comes down to how qualified are they? Because how are you getting over the hurdle in any event that the experts that are going to be called by the defense, who are going to say we were not hired by the defense, are still going to say, presumably at a retrial, that the theory being offered by the prosecution doesn't fit. It just doesn't fit the car. It doesn't fit John O'Keefe's body. So until you get past that, what is any of this doing?
Do you have a minute to watch some of Guarino's testimony? Because
Sure.
he clearly said, I think during direct, that this stuff was destroyed. So
Yeah.
I'm curious. Sometimes I think I'm crazy and I need you to come in here and tell me that I'm not, or maybe I am.
This is interesting.
This is really interesting.
They told the defense that it was destroyed. Did that preclude the defense from getting further analysis done on their own under the theory that there's nothing to give you, and that in theory the defense could have tested this and learned even more data than they did, and perhaps some of that would have been exculpatory? I don't know.
Well, let's take a listen, see if we can figure it out. How do I get rid of that? All right. And this was what day was this? This was June 17th, 2024, day number 26, Karen Reed trial. And this is direct examination of Trooper Guarino.
Direct, meaning how the answer is going to be. This is rehearsed, if you will.
Exactly. But look at how nervous he looks, and how, if you want to stop it at any point, just tell me.
Intimate side, Mr. Wood. Objection.
Sustained.
Okay, here we go.
Now, Trooper Guarino, you had mentioned that you've had specialized training in regard to something called Burla, correct?
Yes.
Could you please explain to the jury what Burla is and how is it used in criminal investigations in your line of work?
So Burla is a specialized hardware and software used to download the infotainment and telematics modules in a vehicle. So telematics module is basically like the SIM card for the car. And the infotainment system is your radio head unit that enables you to have Apple Play, CarPlay, or Android or Google Play for the vehicle.
And at some point, you made aware of a search warrant that was authored in regard to seizing the infotainment system from Ms. Reed's vehicle.
Yes, sir.
And just so the record is clear, can you describe Ms. Reed's vehicle as far as what type of vehicle we're talking about?
Yes, it's a Lexus LX 570 SUV.
And
Notice that he doesn't say what year the vehicle is. I found that curious.
specifically on February 2nd, 2022.
You what?
He's really tense. I mean, usually police officers, they testify all the time. I mean, look at Brian Albert, how calm he was. Whatever you think of him, he's a calm, cool customer. This guy's an active duty detective who presumably testifies almost every day. Not literally, but you know what I mean. And he looks like he's passing a kidney stone. I mean, he looks really, really tense and uncomfortable on direct examination for something that is what you do when you're a detective or a trooper in a homicide unit. You testify in court all the time. And it doesn't mean you're lying standing alone, but my God, does he look tense.
He really does. I mean, it gets worse, if you can believe it.
Did you have occasion to remove that infotainment system from the vehicle pursuant to that search?
Yes, I did.
And once that item was removed from the defendant's vehicle, what, if anything, did you do with it?
After we removed it from the vehicle, it was brought back to Norfolk DA's office for a data extraction, or attempt to.
And that data extraction, if you know, based on your training experience, sort of how is that conducted, or what is the process of extracting data from using Burla?
Yeah. So depending on the system, it's dismantled. They have this specialized hardware that actually goes on to the motherboards of these systems, and we're able to pull the data. Or the other option, if that's not viable, is to do a chip off, where we have to basically destroy the motherboard and take the memory chips off the devices to try to get the data that way.
Now, with reference to this specific device, what, if any, efforts did you undergo in order to extract the information without using a chip off?
So at the time that we pulled the system, it was not supported. I emailed Burla and called them, see if they had a timeline of when this might be supported so we could get the data. We deemed chip off as a last resort because it is a destructive process. So once those memory chips are taken off, the likelihood of trying to reattach them and get it to work again is very slim.
Let me stop you there for a second. When you talk about an item being supported, what does that mean?
Whether or not Burla has the ability to pull the data from that vehicle.
And how is that sort of determined, or how are you able to ascertain whether or not a particular vehicle, make, model, manufacturer is supported by the Burla device?
They have an app, and they also have their tech support. But if you put in the VIN of the vehicle, or if you don't have the VIN, you have the make, model, and trim level, like limited or XLE or whatever, you would be able to go in and look it up and basically say, Burla will tell you, yes, it's supported for GPS points, or it's supported for diagnostic data, or, whatever that they're able to get out of the vehicle. And they work with the automakers to get these, get this data. So.
And approximately how many different types of if we're looking at sort of the entirety of different makes and models of manufacturers, if you know, sort of what percentage of those types of vehicles are actually supported and Burla can actually extract information?
I don't know as of right now. It's a lot, and they're constantly updating it, so they are able to do more vehicles as time goes on.
He's really stumbling here. He's really stumbling here. I really believe that he thinks he knows that he's lying.
This particular time, as you sit here today, June 17th, 2024, the vehicle that the defendant was operating on January 29th, 2022, is that vehicle available or supported by Burla at this time?
The trim level that the defendant had is not still supported. There is Toyota and Lexus support now, but it's not, unfortunately, for her model.
Now, you mentioned that you had reached out to the Bederow company for updates as far as the availability or when the defendant's vehicle might be supported. Is that correct?
That's correct.
And about how many times and over what time period are we talking about that you reached out to ascertain?
Immediately when I did the extraction, I should say extraction, but when I took the system out of the vehicle, I had to reach out to Burla because where it wasn't supported, they actually had to send me tech diagrams so I could go in and, again, not destroy the whole vehicle as I just took those components out. Over the next, almost 2 years, year and a half of going back and forth with them.
Year and a half of going back and forth with them.
With their support and their sales team.
And when you say going back and forth, how often were you reaching out to them, or how often were you getting a response in regards to the Burla?
Usually every few months. I want to say every 3 months, give or take. I forget the exact number, but phone calls or an email to them asking.
Now, beyond that, are you familiar with a national?
Did they turn over to the defense all of this? I mean, all the emails and traffic he had. Did he prepare reports of my attempted communications with Lexus or this company and turn this over to the defense? Because that would all be discoverable. I mean, if you believe this stuff, and he's a diligent detective, you'd think that he would have really papered his efforts to do this. And I don't remember any cross about this. I could be wrong. I was driving the day I listened to this in the car last summer, but this just sounds crazy. I mean, if this was, I hate to do this, but to go back, if this was New York, this was PD, they have these things called DD5s that they would, which is a detective's report, basically. There would be 50, if this took a year and a half, there'd 50 DD5s literally just on this, where it could be 3 sentences. I tried them again, sent an email attached as a copy of the email, or I spoke to this person at this number. It's not working. I spoke to so-and-so, and we decided today's the day we have to try to do a chip off or whatever. And it appear, I think, that they have any of that here. I don't know. I don't remember.
I don't know if that was ever turned over. I mean,
if it exists,
they were still doing this 90 days before trial. And here's where he's going to say that it was destroyed. Hold on.
Cyber crime conference.
Yes.
Went to a cyber crime conference.
On an annual basis, at least.
Yes, I do.
And with respect to that, what, if any, time at those conferences did you spend dedicated to ascertaining the availability or the supportability of this vehicle with reference to Berlin?
So Berla has a booth at the National Cybercrime Conference. I spoke with their sales team there. Their response was to keep calling Berla, keep pestering them, and they might actually get the support sooner than later.
And
They'll
again, were
invent
you
it for
ever
you.
able to ascertain or get the support to download the information from them?
No, unfortunately.
Now, at
Again,
some point,
why, in communicating with Lexus, okay, about what is clearly a technical detail, a service type, an engineer thing, why are you talking to the people who sell the cars? Like, what are they going to tell you other than, well, you got to call them? Why
He's talking to
aren't-
Berla. He's talking to the software company.
Right. But
Yeah.
he's talking to the salespeople. Even why not go to either the software people who are the tech people, the Lexus, the tech people? There's got to be engineers, scientists, somebody. I mean, he keeps saying I spoke to the salespeople.
And it was at a cybercrime conference. Like, he happened to be there anyway. And he was like, hey, do you happen to support this model Lexus yet? And this is easily, I would think, disprovable that if he's lying here, and his, I
If
would think,
I would send a letter, a Brady demand. Everyone's cringing, like a letter. It's not like that, but demanding any and all communications that he had with Lexus, Berla, and blah, blah, blah. And I would cite all of his testimony and say, if this exists, why don't we have it? Or have them commit that he's just going by memory here. And if that's the case, so be it. But why wouldn't you, during the year and a half that they were trying to do this, this is a big thing from their perspective. They're trying to crack the car. This is, and we're not able to do it. And I'm thinking, if you're working for the state police, this is kind of a tense thing. This is not good. And I don't want to be blamed for this. And we're going to have to, down the line, justify what's taken so long, why we can't do this. And ultimately, if we have to resort to a chip off, if that's what it's called, which could be destructive, that we better have a real good paper trail of why we had to do that. And any real cop in that situation would paper this to death. And
yeah.
if they have it, then I'm wrong and I'll be quiet. I don't know, obviously. But if they don't, I would be demanding.
They didn't have any log of the 17 or 47 pieces of taillight that they found after the first day. You think this guy's keeping notes on every time he called Berla? You're funny.
You know what? But and again, I really don't want to keep bringing this to my own experience, but that's what the NYPD would do. That's what you would expect any agency investigating a high-profile, serious homicide where the deceased is a police officer to do, if for no other reason than if they have to resort to the risky way to do it, that they have an explanation that we had to do it. We have clean hands. There's nothing sketchy here. And
Because we
instead,
exhausted every other option.
and instead, if you're putting him up from memory, where his eyes are darting back and forth, he's coughing, he's drinking, he's looking at the floor. He, as I said, he looks like he's passing a kidney stone, and this is a professional witness. He's experienced, he's done this 100 times, 500 times. Why is he so uncomfortable?
Yep. During direct.
And somebody said he had a back injury or something. Oh, maybe that's why he's uncomfortable. I don't know. But the point is, where is the paper from this? Everything detective does, or trooper, whatever his rank is, ought to be documented specifically because of his testimony, where he's saying it's hard. And I'm trying to explain. I mean, he's clearly building up to why they had to resort to, taking a hammer to the motherboard, basically, and hope for the best, right? I mean, that's he's building up to the crescendo here. But
yeah.
So where is all that? Where is that showing the defense? And if you were the DA, you would even ask him to refresh his recollection. You're not going to introduce it into evidence, but you would say, can you tell us how many times you did call? And you know what? If it was 87, you would have him say that. And you would say, who did you speak to? I don't remember. Well, if I showed you your report, would that refresh your recollection? Yes, I spoke to, John Doe from Burla on this date at this time. And you would lay it out instead of doing this gobbledygook.
Customer service rep number 2478.
What you would not resort to is, I went to a trade conference and went to the booth, which is full of people trying to sell you on why Burla is where it's at. And when
And I said, yo.
Not surprisingly, when you ask the saleswoman at the booth who's there to try to sell her product, well, how the hell do I do this? I don't know. You call service.
Keep calling. Eventually, if you keep calling, eventually they'll help you.
How about you guys travel to California to interview witnesses? You travel all over Massachusetts to interview witnesses. We saw when you did your Brian Walsh thing, they're very good at going to Washington, D.C.
They went to D.C. Yeah.
They dumpster dive. They do all the things. How about
Trash
you go
polls.
to Burla with a contingency of people from the state police and the prosecutor's office and say, we need answers. Can you help? And if they can't, they can't, obviously. Why is it being done in this way?
Because it's shady.
Right on cue, the coughing, the hacking.
Yeah.
At some point, were you able to download any information from that particular infotainment system from the defendant's vehicle?
And not from the infotainment system, but Burla released a new item similar to a mechanic scan tool. It plugs into the OBD2 port, which is underneath the dash. So we're basically, if a mechanic went in there with a scan tool to tell you why you have a check engine light, this does something similar. So you plug it in, and then it pulls the car diagnostic data from that.
And as far as the data that you received from that, what, if anything, did you observe?
Again, I got a series of 14s was the numbers. It was no readable data. I reached out to Burla and asked them, I said, is there a reason why it pulled this data, but when I put it into the software, it's not telling me anything. It's not giving me any readable data. And they said they know it is diagnostic data, but they haven't got anything from Lexus to say these 14s, these codes mean this. Oh, they only know it as emissions.
So was Burla itself able to read that information and transform that sort of binary code into any sort of readable data for you?
Other than the number 14, no.
Now,
So they got nothing.
from there, what, if anything, did you do with regard to the Burla and the defendant's vehicle?
Was placed back into our digital evidence lab, and
Digital
then
evidence lab.
we did eventually do a chip off to
Wait,
the device.
So according to him, I have where we are now. According to him, all of the data came from a chip off. They got nothing other than gibberish.
No, nothing. And
Yeah.
what you're going to see, because I've got the information, because they did the same damn thing in Brian Walsh's case before this, like a year before this. All you got to do is plug a little thing, in, just like they did in Richie Schiffer's Toyota truck. You plug something in, you extract the data, and you go away, and you're done. You don't have to dismantle it. You don't have to chip off a motherboard. This is why when I looked at these two, well, and I looked at Walsh and Schiffer, when they did the same exact procedure, it was not destructive testing.
Is there anything significant that this is a Lexus of a particular year, make, and model that makes this?
That's what he's trying to make us believe, but who knows? Because Schiffer's truck was a Toyota. Toyota and Lexus are the same manufacturer.
They are the same. Lexus is just a nicer Toyota, basically.
Mm-hmm.
No disrespect to Toyota.
And Walsh had a Volvo. So, I mean, that's also a foreign, Volvo's a foreign car. So they had it for Volvo. It was an earlier model Volvo. All they did was go in there, same thing, just extract the data with like a USB thing, like he just said. So this is interesting. And now he's going to say.
But also, he says we did a chip off.
Right.
Did we not just read in the motion that Brennan filed that he's basically saying it was the defense who did the chip off? And although Guarino was there along with another government expert, that it's kind of quote unquote the fault of the defense because they did the chip off and they're the ones who destroyed it.
I think that he's going to say that next. Hang on. See, you're even ahead.
Now,
Both devices.
with respect,
Wait, what did he say?
He just muttered.
And then we did eventually do a chip off to the device.
Now,
Both devices.
with respect, excuse me,
And he was like, actually with the Lexus.
to the chip off, that was done sometime in December of 2023. Is that correct?
Yes, that's correct.
And again, if you could expound upon a little as far as, can you describe for the jury sort of the chip off process, why you were reluctant to do it, and what's entailed in it?
As I said before, it is a destructive process. As soon as we do it, we take those memory chips off. It's applying extreme amounts of heat to the motherboards to take the memory off. That'll heat it. You lose a lot of the soldering and capacitors, anything that's on that motherboard. So, like I said, once the memory chips are taken off, it's going to destroy the board.
It's going to destroy the board.
And as far as that
He's
chip
saying
off
we
process, who, if anyone, was present with you, or
Here,
who
listen.
assisted you in removing that or conducting that chip off process with regard to the motherboard from the entertainment system from the defendant's vehicle?
I'm sorry. At the time that we actually did the chip off,
Yes.
yeah, it was myself, AG Speak, and Maggie Gaffney.
And who is AG Speak?
AG Speak is has his own forensic company, I guess you could call it, for Burla. I could consider an expert in the field, former California Highway Patrol officer that exclusively handled stolen cars.
And who is Ms. Gaffney?
She was the defense's expert. She's the one who actually did the chip off, applying the heat and taking the chips off in our presence. And she, I believe, works for...
Blames it on the girl.
I'm sorry, the name of the company escapes me at the moment.
Now, with respect to the information that you, Ms. Gaffney, and Mr. Speak were able to remove pursuant to that chip-off process, what, if any, usable information were you able to glean from that?
As I was told by AG, there was no data that was recovered off the infotainment system or the telematics module from the chip-off.
And as far as Ms. Gaffney, did you have any conversation with her as far as the information that she was able to glean or read or decipher?
No, once she did the chip-off, I had not spoken with her since.
So,
Yes.
so they did the chip off, and the defense expert told him, "Don't worry, there's nothing there." And he just said, "Okay, we're done." And now they have an expert who's going to come forward and say, "We think that there's a chance to salvage some of this.
Mm-hmm.
And we're going to find the data." And then they're going to what? Are they going to now accuse the defense expert in the first case as somehow misrepresenting? I mean,
Pin it on the girl?
this
Or are they're going to say that there's been new, new software developed that now we're able to read it when we couldn't read it all the way back in like 3 months before the original trial?
But didn't he just say that, in essence, the defense expert said there's nothing there?
Let's see. I'm going to hear that again.
Wouldn't he, since he's looking for this data for a year and a half, say,
Right.
"Let me see, let us both examine this and see what's there"? Can we
His
hear
expert
that?
was there too.
Right.
She was able to glean or read or
Yeah,
decipher?
which she was able to.
No, once she did the chip-off, I had not spoken with her since.
I haven't spoken to her since. He didn't say that she didn't. She said there was nothing. He just
I
said he
thought-
hasn't spoken.
Before that, the other person that nothing that told nothing came from it.
With respect to the information that you, Ms. Gaffney, and Mr. Speak were able to remove pursuant to that chip-off process, what, if any, usable information were you able to glean from that?
As I was told by AG, there was no
AG?
data that was recovered off the...
So it was his own expert who told him there was no data. Right? Let's see what this is.
January, early February 2020. Were you provided with some laptop?
Okay, now they get into the laptops, but it seems to me like it was destructive. We found nothing. How are they now going to say, well, now we can find it? I don't know.
Well,
I'm confused by this. Like, if there's new software?
They found an expert who has told them, in his opinion, it's likely that there's data there because it should be this, it should be that. But in that supporting basis for the motion they filed, it was very conclusory. This is what the expert thinks, but there was no real explanation why that would be in light of the fact that their prior expert said that after a destructive chip-off process that there's nothing there. So why now? I mean, I don't know. It's I don't know.
It's bizarre, right? But if we look at quickly, Brian Walsh's so this is written by Michael Proctor. And this is from January of 2023. So this is oh wait, I have to get the correct page. Hang on a second. Page 131. Proctor did a search warrant to get the same infotainment stuff off of Brian Walsh's Volvo. And this was a 2019 Volvo XC90. And here's what they got. Everything off of the vehicle infotainment system. But here he tells us exactly what he expects to find. Page 149. And here's what he says. This is Proctor. And again, this is in 2023. So this is before this, January 2023. Modern motor vehicles contain digital devices that are referred to as in-vehicle infotainment systems. This system is a combination of entertainment and information delivery systems for drivers and passengers. IVI systems use audio, video interfaces, touchscreens, keypads, and other types of devices to provide these types of services. The vehicle involved in this investigation, this is Walsh, a 2019 Volvo XC90 SUV, is equipped with an infotainment system, which is installed within the vehicle based on the manufacturer, blah, blah, blah. These systems are designed to store a vast amount of data, which may include navigation events, such as tracking logs, including location and routes, connections like Bluetooth and Wi-Fi, including unique identifiers, connected devices, cell phones, mass storage, and embedded, which includes device identifiers, call logs, contact lists, SMS or MMS messages, emails, media files, vehicle events such as date, time, locations of doors opening and closing, gear shifts, light status, start stop logs, system reports, GPS warnings, and voice recordings. And this is Burla. And they used Burla. And it says Burla provides a digital forensic software tool to check to see if vehicles are supported for this type of examination forensically. And they got the warrant. All they did was put the little thingy, the little gizmo in.
I think
got all the information.
What they need to do is make a demand for, based on what is Guarino's sworn testimony of all these efforts that, they tried to do this but couldn't. And then we had to resort to, basically a very destructive process that, whoops, didn't work. We need to know who he spoke to, when, any documentation. He referenced emails. He referenced conversations. I'd want proof that he went to the conference. Where was it? Who he spoke to? Da 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 da. And look, either it exists or it doesn't. But it's just hard to believe that he would not have documented over the course of a year and a half the efforts to avoid resorting to a process that, whoops, just happened to destroy what now. At a retrial, we're told will be potentially powerful evidence that the new guy says, well, I think it's likely we can recover this. I'm not sure why, but that's what he says, and he would know better than me, certainly. But why is that?
I imagine he's a mystery solver. This new guy, he's going to solve this mystery for us. Everyone.
He may, who knows? But this is really weird. And of course, if he's able to do it, depending on why he's able to do it, I mean, is he going to say it's just better software? Who knows? But, they can't just disappear Guarino's testimony from the first case and his conclusions, the same way they can't just disappear Trooper Paul and disappear Proctor and all these other problems that they have. And, if they try all these things at a second trial, it's fair game for the defense to note all this and say, you know, how come you found this, but the first guy didn't? And, you know, obviously the new guy's not going to know how this data was stored until the day he saw it in October or whenever he saw it. And again, you know, any scientific test, there are conditions precedent. I mean, who was watching this stuff? I don't know. I mean, you'd like to think that they learned from the first case to just do this the right way and secure evidence properly. But this is, I don't know what they expect this to reveal and why ultimately it's going to solve the issue of him going in or out of the house, or how they expect to solve when the car went 24 miles an hour in reverse, which still appears to be a thing that essentially never happens. And my understanding on this, and I'm not a tech guy either, so is that the way they get the opinion, if you will, in the data that the car went 24 miles an hour in reverse, it's not based literally on travel. It's based on the RPM, or the wheels spinning at a rate and a pressure being applied, which could very much be, I don't know, putting a car in reverse, going up a hill in poor conditions and spinning out or having difficulty, like a tow truck.
Like trying to get out of the driveway in Dighton when there was a lot of snow, and you know, I mean, there's a lot of issue also with the issues with the key cycle data.
Backing it up onto a tow truck and having trouble getting it on. I don't know. But, you know, 24 miles an hour in reverse is apparently an extraordinarily high rate of speed that nobody ever goes. And not for nothing, this is why they're potentially stuck in the middle. If you're going to say that she went 24 miles an hour in reverse and just floored the car, gunned the car like that over that distance and just mowed him down, putting aside the lack of injuries and all that we've already been there, aren't you kind of stuck in the middle? And aren't you now kind of arguing, well, that's kind of an intent to kill? And if your theory is that she did in fact kill him, well, that's kind of an argument for murder, even though there's no real good motive and evidence for that otherwise. And the jury essentially acquitted her of that, whether that's a thing or not legally. This just sounds
remains to be seen.
Like a trial in search of a theory, you know, which again is never a good thing when you're the prosecution and you're just kind of wandering in the desert looking to find the square peg to put in the round hole, which is really what this feels like a couple months out. I mean, it's already mid-October.
Yeah. Thanks, Advocate, for the 5. I think we just addressed that. That's the new stuff on the Lexus that we just talked about. Noel says it's probably a silly question, but would any of this fall under Brady? Surely all of this would have been available before the last trial.
The stuff about Guarino and whether he prepared these reports or evidence that contradicts him would fall under Brady as Giglio material. It would go to his credibility for sure. I don't know what reports he prepared or didn't, but it just seems like he apparently didn't, because I would have assumed they would have just crushed him on cross-examination with this stuff.
Oh yeah, that would have been a fun one. Mike B from the 413, thanks for the 10. What happens when lawyers for Walsh and Kevin Reddington happen to see or hear this related to their clients? Could this be an attempt to deflate the Brady letters sent to those other defendants?
I don't know, but I mean, look, I would be more concerned with Brian Walsh than Karen Reed, right? I mean, as a matter of public safety, you know, notwithstanding how people have this irrational hatred for her, she's not dangerous. Whatever you think she did or didn't do, Brian Walsh appears to be very dangerous and very so I would think that they wouldn't want to do anything that would compromise that. Not that you want to pick and choose, but you know, therein lies the whole problem with the Norfolk DA and using these state police. You know, you do bad in one, it impacts the other, and you really can't pick or choose. You have to go where the evidence takes you, where the disclosures take you. And, you know, if these guys are not credible in one based upon their prior misconduct, then that's going to affect them on the other ones. It's not good.
Turk as well. Dreamer Thinker, thanks for the 15. What do you both see as the percentage chances that major corruption is revealed And a transformation in Canton is emerging before July 4th of 2025.
What's so big about Independence Day? Is that
I
just
don't
a line?
know.
I don't
I
know.
don't know what that date has to do with that.
I don't know. Maybe they'll arrest some more people for littering by then. I don't know. As far as busting up major corruption, we're not in government, so we don't know. We don't know what'll happen. There's no way to know.
think
I
it was
wouldn't
a
even. I'd be
funny
guessing.
rhetorical question. Thanks, Dreamer Thinker. From the UK, we already addressed this. Thank you, Charlie Lynn. Amber Dawn, I think if they would not have implicated her lawyers conspiring along with Turtleboy and Karen, grand jury probably would have indicted them. Thank you both so much.
Well,
I don't know if the grand jury heard anything about the lawyers, though.
Not going to get into the substance of the transcript of the grand jury. All I'm going to tell you is, as was made public, they sought an indictment against Karen Reed and Aidan Carney. They presented evidence on March 27th through the testimony of Brian Tully. All that is in the Cosgrove letter. And the grand jury declined to find probable cause. And the letter, or the motion, I should say, that was submitted to the court in May said, it is our belief, and this is very crafty language. He didn't say we're presenting or have or this. We think that Karen, her lawyers, and Aidan did this, which to me also does evince knowledge that they knew the grand jury dumped it. Because when do prosecutors ever say we believe? In other words, they may not have charged them, but we think this is what happened anyway.
Yeah. Susie Q, if FBI investigated not in why could witness intimidation charges?
If the FBI is investigating.
Well, it also says here, Lally didn't give notice to Bradel to exclude Aidan. Susie Q, I don't know if these two things are related.
I don't understand this one. There's a lot of.
I can't decipher it either. Della, thank you for the 5. In my opinion, appeals court is using supervisory powers to act on Weinberg's argument because they're sick of this too. Slap to auntie, mockery of justice. World agrees. Thanks, Della. I can't wait to watch the oral argument on that November. I think it's November 6th. Mike B from the 413 True Bait. Oh, we told us that before. Thank you. Yuri was at 34 Fairview during that time. Had a crew with him, probably the new engineers. Says Glamasuz. Thank you. A1 video, Flipperhead. She's telling them everything. Thank you. I think I saw that. I don't know if you saw that.
I didn't see it, but I remember it. And it's one of those facts that I don't know how anybody can find normal when somebody who knows nothing about nothing and has nothing to do with anything and is totally innocent and says, I always told the cops that this is what happened, even though the cops don't report that. Forget the Google search. You delete a whole number of messages and do other things. You prepare a timeline. You go hang out at Proctor's house. And, she's telling them everything. Well, who cares? Don't you want to find out what happened to John O'Keefe? Isn't that a good thing? Why is that a point of concern? All of this is suggestive of people who are very concerned about, the cops finding out that he was in the house. And of course, tell them he wasn't in the house. So none of this makes any sense.
Yeah, for those of you who don't know, this was when Jen McCabe, Carrie Roberts was giving a statement in Jen McCabe's living room, and Jen McCabe said in the group text, I think she's telling them everything.
There's a very underrated fact, too, in all of these searches that came an issue with Jennifer McCabe that I don't think this one was in dispute. But when you look at the timeline about what happened to John O'Keefe, she starts Googling herself.
Yeah.
And then she Googles herself, I believe, with John O'Keefe. Now, who in the hell during a period of shock and horror and something terrible is happening?
Horrible grief.
Well, whatever.
Dear friend. Yes, all of it. Yeah.
Why would you say, in essence, oh my God, is anybody saying anything about me and him or linking me to this?
Consciousness.
I don't know. I don't know why that wasn't a little bit more enhanced too. I mean, that's not normal. That's not normal.
Consciousness of guilt.
To some extent, yeah. What do they know about me and him?
Right. Has anybody made the connection? Thanks, I'm just a girl in the world. This is a head scratcher. Thank you so much. Local wars. Thanks for the 10. Not to beat a dead horse, but has the house ever been forensically evaluated? With that much blood, something's got to be there. I mean, we saw the video coming out of the bulkhead doors. It's a bit since the new owner was there. I don't know. Who knows what the FBI is up to? Pin it on the girl. Thanks, Kale. Liz Swift, how high up and wide do you think the corruption goes? I would be a fool to even venture a guess.
Who knows? Look, it's not normal. Okay, let's just put this out there. During the pendency of a state murder case or prosecution, not trial, that the key prosecution witnesses were called to testify in a federal grand jury about the same incident, and that there was an exchange of letters back and forth, and ultimately the district attorney whining to the OPR, the Office of Professional Responsibility in Washington, and getting a curt response. Yeah, we're good. Thanks for your caring, but we'll do it our way. That none of that is normal.
No.
It's not normal for the feds in dealing with the same prosecutor's office to indict a police officer who got a clean bill of health for what really, in essence, is a state murder case. I know they wrapped it up in a federal witness, but they needed jurisdiction to make it a federal crime. That's not normal to take a state suicide and say, yeah, you know what? Not so much. We're going to go ahead and indict that guy that you gave a clean bill for murder. So there is clearly something going on here with the U.S. Attorney's view of the competence, and perhaps much worse with the local DA's office. I mean, that's clear.
Yep, he was begging for information on that. It was like a desperate plea for information. Hi, Canton Cubert. Hello. I used to be so good at that game, Cubert. Thanks for coming in and throwing in a 5. Chen's missing tooth. Thanks for the 5. This is just so everyone doesn't hear telematics. A la Trooper Paul, we need the truth about the telematics. We can read. Turtle Boy. But again, why are they able to find it now when I thought he said it was destroyed, and now, the motherboard was destroyed, but the chips weren't, but there's still info on the chips. And this guy contacted us, maybe just contacted us and said, hey, I think I can help. Who knows?
Well, here's the key question of the day. It seems like the Patriots have a really good shot at the #1 draft pick.
Well, let me just say that Travis Hunter plays for the Colorado Buffaloes. That's my alma mater, Sco Buffs. We lost last night, but it was a nail biter, and it didn't end. I fell asleep before it ended at like 2 a.m. Travis Hunter is amazing.
There's a decent chance the Patriots are going to have their choice. But what we saw today was Drake May threw 3 touchdown passes, 2 of which were very, very impressive. He also threw an interception where there wasn't a red shirt within 20 yards. That's not so good. Threw an interception on a screen pass, which is almost impossible. And, so it's not all perfect, but he has that kind of like Josh Allen, raw, unpolished effort, if you will, right now. So I do think they got a real quarterback. So they still suck. They got blown out.
Travis Hunter's not a quarterback.
No, it would not. No, they would need help to go with the quarterback, obviously. No, but I think we have a keeper. I think we have a keeper.
I think that if Travis Hunter goes to the Patriots, I will become a Patriots fan, and I will go with you to games, and I will be right there in my Patriots jersey of Travis Hunter because he's amazing. Plays both sides of the ball. Do you know this guy? He's unbelievable.
Yeah, unbelievable. I'm familiar with him. I mean, going to Patriots games now is a little different than 5 or 6 years ago. I mean, they've actually lost 8 straight games at home, which is literally a season's worth. And this is a team that would basically never lose, period, essentially, for 15, 16 games at a time. I think they have the all-time record. It was 21 or 22 over 2 seasons, and that's not even with the perfect season, which is a whole nother conversation. But they stink right now. So, and they're going to stink next year, but it's all right. They'll get better, hopefully.
Well, you never know. Is it possible after redoing the test and the special DA dismisses the charges?
Look, maybe, but there is language in his motion in which he makes a conclusory statement that Karen Reed drove a car and mowed him down and killed him. And if there's no way in which a prosecutor is going to conclude that she hit him, but it was an accident and she didn't even know and therefore is not criminally responsible if you think she did it at 24 miles an hour like that. So, not with that kind of language. I mean, that's not how you would write it if you were doing this in a way where you're playing it down the middle, literally, and keeping all options open. I think he's keeping options open on the charges, but you don't put in conclusory language, when she mowed him down and killed him, if you
Yeah.
have inclination to dump the whole thing. Sorry.
Mm-hmm. Yeah, agreed. Quack job. I don't know if you can answer this. Question for Law Daddy. Can you guys request Jen McCabe's extraction report for your case since she's a named victim?
I'm not going to talk about that.
Yeah, I didn't think so. All right, but thanks for the 10, Quack job. Appreciate you. Thanks, PU, for your super sticker. Misadventurous Book Mouse, not supported, just at like Karen Reed's phone. Since the jury can't know it's a retrial, how does the defense inform them? The Commonwealth presented a flawed and botched first investigation and trial, Amber wants to know.
First of all, there's practical and legal. No, the jury is not supposed to know there's a retrial. If you don't think every single juror who gets picked at a second trial is not going to know that this is trial 2, forget it. They practically they all know. Number 2, you'll see the magical other proceeding that you heard in the first trial. Evidence that's relevant is going to come in. There may be ways that you have to couch it like they did with ARCA in the first case, but they're going to know that this is not the prosecution's first expert and that presumably their second expert is going to criticize the first one for being incapable of doing things. And this relates to the car reconstruction as well as the infotainment. Whoever replaces Paul, whoever replaces Guarino, whoever, they're going to know.
Yes, just like they handled the grand jury testimony, how they danced around that in the first trial. Baby Fishmouth, thought bubble, perhaps Hank Brennan wants the extraction to determine whether it exists or not. And if not, he's got a reason to drop the charges. I think we just
That's
addressed
wonderful,
that.
except why write in such strong terms that it's my view that I know she did this if you're keeping an open mind about that. That doesn't square. Maybe it's just sloppy writing and editing. I don't know. But that doesn't mesh with the statement that was given when he was first assigned. That's all. And I'm not even, whatever. If he thinks she's guilty, he's going to try the case. So be it. All I'm saying is if you're really thinking about dumping it, you don't say the defendant's guilty in your filing. That's all.
Exactly. Furious. I wonder why they're not going to use their superstar AG Speak for the next trial. Why didn't they use him in the first trial? Right? Didn't find anything, I guess. Dewey, here's a few bucks to help Chuparino buy some paper. Thank you. Thanks, Dewey. Thanks, Andrea. Andrea coming in again. Thanks for 20. I had a Lexus older than Karen's and one the same year as hers, I'm pretty sure. And when you're backing up, it automatically brakes when you are backing up and starts beeping if something is behind you. This makes no sense. They didn't get into it too much in the last trial, and I was wondering about that too.
She had what year model she had? 20 or 19? I don't know.
I don't remember either.
I've had cars like that where if there's something literally there,
automatic braking.
She
had a 2021.
So that's pretty up to date for the time that this happened. I mean, that would be the most recent model. It probably, I don't remember the testimony on this, but she probably did. I mean, if there's most cars, and Lexus obviously is a high-end brand, and she had a high-end car, is going to do that.
Yeah. That's it. My car, I think when I'm backing out of the driveway and I go like 6 miles an hour, it starts beeping like crazy. Like you're going too fast. So some of them do. I don't know if in 2021, if they had the automatic braking, I don't know. Cheryl Kelleher, do you think the defense is going over this as thoroughly as you two?
I would say take us and add 8,000 hours and 8,000% thinking about this 24 hours a day. Say that, yeah, they're doing this not as thoroughly, but much, much more thoroughly.
Right.
But they've got a client's life on the line here. So, yeah.
I'm happy to help. Happy Thanksgiving to all my Canadian friends and your Canadian friends. And Thanksgiving in Canada is tomorrow, right, Charles? So happy Thanksgiving to all of you Canadians who celebrate. Alyssa, do you think the defense will fight this motion from the Commonwealth? Will we be getting a hearing soon? I mean, they're going to have to oppose it, I would imagine.
I mean, you can oppose it, but I mean, if they're saying we have an opinion that there is relevant evidence that can be extracted that we were previously led to believe wasn't, she's going to allow it. This is not a Canonius corrupt thing. That's
right.
Judge would do that. Now, but how did they not know this before? That's all for trial. If they submit, credible papers from an expert basically saying, and we didn't see the exhibits, what they were and what his opinion was and all that other stuff. The judge is going to say if there's a path to develop evidence that's relevant, yeah, I'm going to allow it. So
unless there's a chain of custody issue that they can show or a spoliation, they can make a spoliation motion. I mean, there's are ways of fighting it. Or if they think that the information could be exculpatory, they'll be like, sure, we'll send our expert. Like they need to talk to their expert too.
Also,
to see if this is even viable.
And that's also, clever drafting, and maybe they mean it. I'm not assuming Brennan's a bad guy here. But he says this could be exculpatory or inculpatory, which is a smokescreen to a judge and to the defense to say this isn't all of our interest. We're kind of going into this blind. We don't know, but a judge will like that. This is fair. And again, I'm not doubting that he's trying to be fair. I don't know. I just don't like the one sentence at the end that assumes after all this that she must be guilty. On the other hand, he brought in the prosecutor and he said, I'll be ready for trial in January, the first day he got in. Well, you don't try the case if you don't think she's guilty. So, but that doesn't mean he can't do it ethically and honestly. I mean, he gets kudos for bait stamping. So, that's progress.
Except they only called it bait and not Bates.
Oh.
It's Bates, like Norman Bates, because this is kind of like Psycho in a way. Sarah, thanks for the song lyrics, putting in some Neil Young song lyrics. I caught you knocking at my cellar door. Oh, the damage done. MAGA Stacker speaks volumes of the MSP when the prosecutor is keeping those previous troopers from tainting his retrial.
It's unheard of that they have to basically separate themselves from the police investigating agency. And it's almost unheard of that you would try a murder case like this and you would wait until the very end of the trial to call, the lead detective. And would never mind the nonsense they tried to call him. He was the lead detective, okay, Proctor, because they didn't know what to do. And, in almost every case like this, you're going to have the lead detective early in the case kind of take the jury's hand, hold it, and walk them through and navigate all kinds of things that we did. And they didn't do that. It's not normal that within, a week or two of a trial ending that 3 of the main police officers are immediately put under internal affairs investigation. 1 has been sanctioned, if you can call it that. 1 is hanging by a thread, almost certainly will be terminated. The 3rd one, we don't know. So none of this is normal. And it's entirely not normal to bring in a ringer at taxpayer expense for a retrial. That is totally unnormal. What is normal, you have a conflict of interest that you have to step aside. You bring in, the Mello and Cosgrove, if you will, because, there's a perceived conflict. But bringing in an outside trial lawyer because we're allegedly or apparently incapable or no one will do it, don't discount that. It may be, who wants to try the case and everybody does one of these and there's nobody left. And what am I going to do? None of this is normal. So,
and he's a defense attorney. He's taken a major pay cut, in my opinion, to come and take this case over. He's got a contract that runs until June of 2025 for $75,000. I mean, if you got a really successful defense practice, that's
lawyers don't always do everything hourly. Okay. And criminal trials, a lot of times you don't, but somebody was crunching the numbers, whatever, at 75,000 or whatever it came out to. And what did it come out to? Like
300 hours at $250 an hour.
That is, in the real world, people, nothing. Okay.
Yeah.
In today's If you're a very high-end attorney in a big city, and obviously Boston rates are not the same as New York or LA, but Boston is high, and Mr. Brennan is at the high end of the food chain here. Clearly,
Yeah.
that is an extraordinarily low hourly rate if you extrapolate. I know that's one of the words of the day. To an hourly situation, if you're coming out making 300 an hour, that's actually very low. If you
No, 300 hours at 250 an hour is what it is.
Yeah, well, 250 is, you're not getting, I mean, lawyers in big cities in doing hourly work, if that's what you get, I'm talking at like a high level, or
Yeah, divorce lawyers are billing out 1,500 an hour in LA. Okay, this is not
it's easily 1,000 and above.
right.
Easily.
Yeah. Thank you, Rose, who says there's no flies on this chat. Thanks, Rose, for the 10. CMO 8. Thanks for the 20. First jury discounted ARCA experts' testimony because they thought Turtle Boy paid for them. Can the defense disclose this time? First jury discounted ARCA. Okay, same question twice.
It's a problem, and I think they need to address it with the court, that you need to do better than just saying neither side. You need to change the language to say that neither Karen Reed or anyone associated with her, including insurance companies and and really make it clear that it wasn't her. As far as one of the jurors saying they thought it was him, that's a potential issue with the jury, which ironically would, under current law in Massachusetts, allow the jurors to be hauled in to talk about, acquittal, not so much, but like we thought the journalist is the guy who hired the ARCA people, that would allow it. This is all, kind of ass backwards, but I guess we already knew that.
Thank you, Joseph Kane, for gifting 2 memberships. Bama Girl, why hasn't it been brought up that Auntie Bev has rented a beach house to the Alberts? Conflict of interest? I don't know that that's an actual fact. That was brought up, that she had some connection to them in the original motion to recuse pre-trial.
It would never come again. They tried.
She said no.
But also, and as I did go back and watch some of that hearing, I hadn't seen it before. I do remember she gave an opinion saying there's no conflict, meaning actual conflict, but she didn't address the appearance of one. And if there was any kind of relationship at all, not that she would be affected by it, that she would rig her rulings because, one of these people bought our house and they Venmo'd me money or whatever it was.
The Nagels.
But that does create an appearance that many judges, I think, would say, you know what, fine. She didn't. I get it, but that's not going to come up again. I mean, that ship has sailed.
Right. You want to avoid the appearance. It gave her the opportunity to say, you know what, I did never rent them my house. I know they spelled my name wrong on that Venmo, and it has nothing to do with me, and I have no connection to them. But in order to avoid the appearance of impropriety, I'm going to step away from this. I'm going to pass the baton to someone else.
And the reason you do that is exactly what's happening now, because 80% of the people who follow this, and I do not include myself in that 80%, believe that she is corrupt to her core and was favoring them for personal reasons and whatnot. And then they talk about, well, wait a minute, didn't she rent her house to the so-called McAlberts or whatever? That's why when there's an appearance of a conflict, you step aside to avoid this, even if certain people like me don't believe it's why she did what she did, even though I think some of her rulings were wrong. Whatever. We lawyers always think that.
Sure.
But that's the problem with an appearance. We're talking about it now, and we wouldn't be if she recused.
Thank you, Justin Green, for the Cash App. Says, please say hi to your supporter, Terry Robbins. Thank you, Terry Robbins. I'm not sure what that is, but he wants a shout out. Thank you, Mama She, for your Cash App, who says, thanks for another great show with Mark. I don't know how much more time you have. There's not really some more comments here. Let's just see. We have... we addressed this about maybe dismissing the charges. Thank you, Sue. How can the FBI get in the house? They just have to ask the new owner, or really
any number of ways.
Yeah. And then we can assume that if they wanted to, they would have by now. The explanations about how the GPS is wrong here, says G. Thanks for that. Did Karen's car have a backup camera? Asked Wendy Muller. I'm sure that it did.
Has to. 21
Yeah.
likes it. No
But,
way.
they couldn't get any information from the infotainment system or the telematics because they fried the motherboard. Thanks for becoming a member, CMO8. Jenny, aren't we all mystery solvers? I walk into a room and wonder why I'm there, solving mysteries every day. Right? Or you're driving somewhere and you're like, how did I get here? Thanks, Andrea. Chiming in. Do you think the feds will ever show back up in this case?
Look, they dumped 3,000 pages, presumably hoping that would stop
Thought it
the
would be
trial.
enough.
And there's no way that was everything. Will they do something similar because there's no need to hold on to certain information that they previously held? I don't know. That's kind of the wild card. And if they do something that is dramatic and just kneecaps the case, then, there they are. But it's not normal, again, for the feds to basically try to stop a state case without getting directly involved. That is virtually unprecedented.
Furious AG Speak was deceased Commonwealth expert. Thank you very much. Thank you, Decline, for becoming a new member. How can the defense use this to benefit Karen?
Well, use what?
I don't know.
Okay.
Any of this discovery exchange or the motion to now find some stuff on the chips?
I mean,
Depends on what they find.
There could be disciplinary records for key witnesses from the state police in there.
Mm-hmm.
That would be helpful. We are told, I almost feel like we're burying the lead here. There is a 77-page extraction of Jennifer McCabe's phone in there.
Yeah.
So,
using a new version of Celebrate.
Right, which may or may not say whatever. I don't know. And not related to the, I said it related to her web searches, right? So it's just going to be the Google type stuff. We'll have to see. But any evidence that's disclosed potentially has some value to the defense, whether it's
remember, just because they're turning it over doesn't mean that it's only beneficial to them.
Right.
It can also be benefit, but without us seeing the exhibits of what was actually attached, it's hard to opine. But I'm sure there's some stuff in there that could be useful for sure. Play the first couple minutes of the Flipperhead video, please. I don't like to play other creators' content without their express permission, but everyone go look for that. I think it's on Twitter, or is it on YouTube? I'm not sure. Persephone's Pomegranate, late fees for the rewind crew. Thanks for breaking it down. Thank you so much for coming in from Canada, and happy Thanksgiving to you. How about them Oregon Ducks? Number 2, baby.
That was a big win.
Thanks, Wrestler's Mom. I'm sure Lexus engineer handle law enforcement investigations under direct subpoena from time to time. Just saying. Could be John. Beat a bot. Starting late. Love the 3-point Patriot hat. Melon Will 2024.
I listen.
Thanks, BLT.
This is the logo of the loser Patriots, as everyone knows, like from the 1980s and 90s.
Oh, that's vintage, yeah.
Flying Elvis became the Tom Brady winning Patriots, but the old logo is so much better. And for years, a lot of people wanted them to change it back, but you couldn't because it was just associated with loser. Hello, the time could not be any more perfect to shift the narrative, shift the marketing scheme, go back to the better logo. You stink, you'll get better. Brady's gone. Go back to Pat Patriot, please. For the love of God, Robert Kraft, if you're watching, some of you in there who who you are, who know Robert Kraft, do it now. Better logo.
Thank you, Virginia, for the matcha lattes. Nico 2020, I have the same year car as Karen. Has auto brake. It can be turned off, but not sure how. Also, that is why they destroyed the black box.
Well, obviously, if there had been evidence that she turned that off and they found that, they would be jumping up and down saying, game over, right? I mean, that would actually support a murder charge. I mean, if you believe this stuff, that would show an intent to make sure. But that also doesn't make any sense because if anything, this would have happened. And I don't believe this happened. So don't, shoot the messenger, people. But if you even want to believe that she would have done this, it would have been spur of the moment, lunatic, crazy, I'm pissed off, and just naturally, in the middle of or the starting of a blizzard, throw it in reverse and mow down the guy. Everybody knows I just dropped off here. And I know there's 10 or 15 people or could be in the house literally feet away. That house is very close. It doesn't make any sense. It just, it doesn't. they tell you how calculated she is, right? That's one of their criticisms. How well, that would not be a very calculated way to take care of business, so to speak, if that's what she was going to do. I just don't think it makes any sense.
There was so much chatter before the trial, like, yeah, look at her hand. You see her hand when she's backing out of the driveway in the morning. You could see it's in the middle. She's turning off that auto, like all this nonsense. And then it never came out at trial. The same thing, like when the jury was going on the view of the car at the house, and they said, make sure you pay special attention to the center console. And we never found out what that was about, the center console, because that's where you turn off the auto brake. Everyone was hypothesizing that. It never came out. So,
the defense, they got injured by the crime scene visit being so early in the case. You're talking about the center console, because by then the jury didn't know what it meant. But, if there was a way to negotiate a better timing of the crime scene visit, or arrange for a second visit during their case after the evidence comes in, I think juror jaws would be on the floor when they see that you could basically spit from the bedroom window of Brian Albert to the flagpole and the curb, okay? And that the dog heard nothing. If you see it, and the pictures that the prosecution offered, I'm not saying they were doctored. They weren't doctored, but they were angled in a way to make that yard look much farther back from the street than it is. And if you drive by there, it's so close. I mean,
you did the drive-by, right? Yeah.
Yeah. One day I was having breakfast in town and said, I had to go back down towards Foxborough anyway, and it's basically on the way. And
did you creep up to the front door and turn around and take some pictures and then creep away?
Get out. I did not take the camera out, and then I did not spot the homeowner start, jumping away. Interesting flashback on that. The video that they were playing last night, we talked about earlier with Court TV and Coffin Daffer. They were outraged about alleged trespassing on Michael Proctor's property by people who went and allegedly spit on his driveway. Putting aside the fact that, one person may not be legally responsible for the conduct of another, not what I'm talking about. She was so appalled at the idea of this trespassing. So naturally, a few months later, she's creeping around stranger's house, and then presumably when recognized there's a camera, is running away.
But there was cars in the driveway. I mean, it was like, of course someone was home. There were 2 cars in the driveway. Like, what did she think? I mean, it was just.
Listen, it's one way to do it. It's welcome to Crazy Town,
Man, lunatic fringe. John, the actual car track log should be illuminating for both sides as long as not tampered with. And this is a setup by oppose, rather oversee. You could just stipulate to it instead of opposing the motion.
I think that's a fair point. I mean, everybody's so wants their own narrative and pushing, and I want to win, and I want these other weirdos to lose. If you take a step back and you just say you want to know what happened, and you're confident in what the evidence is or isn't,
right?
There's no real reason, if you can accept that it's real evidence and not tampered with, that it's a bad thing to have it come in if it leads to truth. I mean, that's a fair point.
It's just more cost, more everything, but that is the nature of a trial. It is a living, breathing, moving thing. And lies don't need an airplane to chase you anywhere. Avid Brothers, can the MSP can't have opposing opinions for different cases? Well, I mean, shield and sword. So there's that. Thanks, Jen's missing tooth, for the 5. You can't say in one case Celebrite is inaccurate and completely flawed, and then say in another case that Celebrite is the gold standard and everything is 100% accurate.
Well, that's one of the reasons why they're going to have problems with some of these witnesses, which is, I think, one of the reasons they want to get rid of Guarino. He's just too all over the place.
Mark, my first and only pro football games were the New England Patriots and Seattle Seahawks in Kingdome in Washington. Loved. Thanks.
My very first New England Patriots game, which my father took me in 1984, was in a crappy stadium in Foxborough against the Seattle Seahawks. And for those old-time Patriot fans, it was the debut of Tony Eason. And at the time, I think it might have been the biggest comeback in Patriots history. They were getting killed. They put in young Tony Eason, and they came back and won the game.
I saw the Grateful Dead at that old Foxborough Stadium many times. It was a fun place.
Sullivan Stadium or Schaefer Stadium, they used to call it after that well-known low-quality beer. Oh, that place was such a dump.
It's Schaefer. Was it Schaefer time? No, it's Schaefer is the one beer to have when you're having more than one. Is that Schaefer? I don't know.
Totally. It's so gross there and so
Thanks, Linda.
crazy. For years, they were, I mean, well, part of the problem is they sucked, but the other part of the reason why they never had Monday Night Football there, it was too rowdy.
Oh.
It was just too like low class.
Thanks, Karen, who can't figure out how to gift memberships. I don't know. Maybe because you're not in the US, maybe one of the mods could help you with that. And thank you so much for wanting to gift memberships and for that you were lucky to receive one the other night. Maybe somebody in the chat can help you because I have no idea how this whole thing works. Andrea, I still have my 2021 and it even shows your driving score. Oops, wait. It even shows your driving score. My son drives it now when he rather takes something that doesn't suck as much gas as his truck, and it shows me his driving score when it breaks because he's a teen. I don't know what a driving score is, but I'm sure it gets reported back to your insurance company.
Yeah.
Because they're collecting data on you all the time. All the time. Thanks, Andrea. It will prove her innocence. This is good, she says. All right, Andrea, good. She's got the same car. Thank you.
Everybody's telling I'm sorry, everybody's telling their funny stories. I don't mean to interrupt you, but
No, not at all.
They're funny stories at the old stadium in Foxborough. And I'm pretty sure that up until the last couple of years, because, you know, if you walk around New York City now, it's a cloud of pot smoke. I think the only time in my life I ever had a contact high was at the old stadium in Foxborough to see Pink Floyd in 1994.
Mm-hmm.
But yeah, that was, you know, with flying pigs too, that helps.
Mm-hmm. A lot of pot smoke at the Grateful Dead shows too. And I remember that year. I can't remember what year it was. I think it was like 1991. It was a summertime show. It was around 4th of July. It was so hot that people were passing out like in the field and they had to hose down the people that were in the field. Like it was wicked.
Well, they might have been hosed in there. It's like, you know, wake up, hippie, just get them out of there.
That too, but really the heat was oppressive. Southie roofy weather. Thanks to the 20 with Sallyport video camera reset showing 010101 timestamp. Mark, we got Woj. Boom. You guys make our hearts swell with hope. Love you and Melanie and Mark. I don't know if I love you, Melanie and Mark. I don't know if I pronounced that right.
Woj? You mean
Woj? Yeah.
Woj bombs, as in like the NBA reporter? What are we talking about? Maybe she goes to, I think he went to St. Bonnie's, right, to become their college program director. I don't know. But even if they flip the video around the right way, is it going to magically show like the right thing, or how does that even work? I don't know.
I don't know either. But it's going to say, oh, you know, it always recorded that way.
Okay.
Your guess is as good as mine.
The obvious question would become why?
Right.
What would be the purpose of having a security video that is backwards? That doesn't seem to be a good thing. I don't know.
Yeah.
In a police station of all places, that seems odd.
Right. What about the butt dials with a Commonwealth address? Nothing that was turned over indicates that to me.
I mean, they're going to have to address it by claiming what? Like
nothing new.
You know, never mind the man behind the curtain. What else can you say about it? It's terrible evidence for them.
Well, you know, Brian Albert sleeps with his phone in between him and Nicole apparently every single night. Emailed you a PDF, says Brian, you should read. Ties CC2. Thank you, Brian. Victor Mann, the guilty statement was required by Morrissey. I'm not sure what that means.
I think he means including that in the motion. If that's the case, and I don't know what.
Oh, got it.
If that's the case, most lawyers would say, adios, amigo. Like, if I'm here to do it, I'm not here to have you whisper in my ear and, you know, be your propaganda machine. That would be really disturbing if that's the case. And frankly, I doubt it is. I don't think any lawyer who values their own credibility and has a reputation of being good at what they do is going to get told by Morrissey as you're investigating or reinvestigating a case to make sure you say she's guilty in the filing.
Right.
I mean, at that point, dignity would require the lawyer to say, yeah, have a good time. I'm out of here.
Mm-hmm. Thanks, Kristen. Excellent use of wicked. Thank you, Carol, for your Venmo, who is thanking us for our knowledge. And wondering, Mark, if you've got any other Any closing remarks? Anything that you would like to say in closing? I think I've kept you here long enough, and we've covered a whole hell of a lot in less than 3 hours. So
Yeah, no,
kudos
it's
to us.
they're disclosing evidence, which is good.
Mhm.
They're bait stamping it, which is good. This is all good. I mean, the evidence is what it is, and it ought to be disclosed. You want to, and I think, and I stand by this, I think that the defense will actually benefit by having a more experienced, more skilled, and more analytical lawyer. I mean, look, if Karen Reed is not guilty, it's not going to change because the better lawyer is trying the case. The evidence, as the dog is like sniffing.
Trying to look out the window.
Come on, Lola.
like-
What are you doing?
It's like the Canton leaf blowers are here, Dad.
God, seriously, God, look at her. She's like she's like walking asleep. No, don't sniff the books. No, those are first edition. Don't do that.
My stash, man. Get away from my stash.
She smells something. I think it does benefit the defense to have a more skilled lawyer, cut through the BS, make it faster, and what I call a better cadence to the trial. It flows better. I mean, even watching that direct examination for 5 minutes of Guarino was a little like, you kind of just, it's just a vacuum cleaner, like sucking the life out of what you're watching. And I think having just a more like a tennis match volley at trial is better. And I don't think the defense is going to lose any sleep. And I don't think anyone should assume just because people post on Twitter, oh my God, there's a legal filing and the DA says they're going to do this,
Right.
that constitutes, okay, I don't think that constitutes breaking news and it's time for the defense to load up their briefcase, pack in their bags and go home. It's over because, Twitter says so.
There was a little PTSD involved with watching that. I agree with you, Abby. I was like, oh, you're just hearing that voice again and hearing like the what if any, the lollygagging of the dragging this out for 9 weeks. Like it should not. Hopefully this is going to be streamlined. It's going to be easier to digest and it's going to be quick, not guilty. Dewey, so what's in it for Brennan?
Do you ever watch Indiana Jones and the Temple of Doom? Fortune and glory, kid. Fortune and glory. I don't know.
Maybe he's got political aspirations. Maybe he wants to be the next DA of Norfolk County. Who knows? I
mean, all kidding aside, I don't know. But you also have to understand that prosecutor or defense attorney, when you're a lawyer and you get involved in big cases, and lawyers have big egos, as you know, naturally you're going to want to be involved in a big case. Now, when that runs up against but you're kind of on the wrong side, like open your eyes a little bit. It makes you wonder why he would do that. But he may genuinely believe it's a real case. He may genuinely believe that there's evidence to support Karen's guilt. That's okay. I mean, not everyone has to agree. It's better to have somebody with that point of view who is sane than some of the other people who scream and yell about why she's guilty online, that don't really rely on rules of evidence, rules of procedure, burdens of proof, because they don't understand these things. Okay, so, but only he can really answer why he'd want to do it. I don't know.
Yeah, I mean, your guess is as good as mine at this point. I mean, I just don't know.
I don't know. I mean, if when it's over, I assume someone will ask him. I mean, a reporter should probably ask him now. I mean, it's a fair journalistic question to say you are a top level defense attorney. You haven't prosecuted in all these years. You presumably make a decent living. You're not doing this to stay 2 steps ahead of your creditors, if you will. You have a living. Why would you dedicate all this time, effort into a case that you probably know nothing about? And given your prior statements that anytime I see bad police, I'm going to destroy them. You went after the federal government in the Whitey Bulger case, which is fine, saying how corrupt it is and they're the criminals. Do you still believe that? Does that influence? I mean, there's a lot of journalism questions here that they should have asked that they just haven't. But, until then, you don't know why, because you don't know what he's going to say. It may just be an interesting case. He wants to do it, but I would think journalists would ask those questions. They're fair questions. He may not want to answer them, which is also fair given that he's prosecuting the case. But I don't know why none of the mainstream journalists didn't ask that. And I don't know why they didn't ask Morrissey. You haven't. Can you tell us whether have you lost confidence in your trial team? And if the answer is no, then why are you doing this at taxpayer expense? Did you try to have someone else in your office take this case and did they all say no? Then why do you have an outsider at taxpayer expense? Are you afraid people in your own office have lost confidence in you and don't want to do this? Why did you file papers, excluding someone from a courtroom, knowing there had been a no true bill? I mean, those papers are filed in your name. You don't sign them, but you're the DA. The buck stops with you. There's a million questions that journalists could be asking about all of this. Journalists could be asking the DA, why did you use Trooper Paul at the first case when you knew that there were these experts from the feds? Right. Why did these experts that Hank Brennan is getting now, why didn't you get them before? I mean, these are fair questions. He may not answer. They're all fair questions.
Didn't he take on Whitey Bulger without a hope in hell of winning, but to put him on the map, says Siobhan.
Whitey, well, that's an interesting thing because that that case was just all about, as a defense, screaming and yelling and attacking the government, and yeah, it's fun. Whitey Bulger was never getting acquitted, so yeah, it did put him on the map. So good for him, but I don't know that. I mean, he got picked to do a big case for a reason, but it's a big case and a loser, so I don't know.
We both rock the free world. Thank you, everyone. Thank you, everyone, for tuning in and spending part of your Sunday with us. We appreciate you so very much. And to all of you out there, thank the moderators because they kept it classy tonight. Smash the like button on your way out because that is a very kind thing to do for the channel. And it also helps the algorithm share the stream out so everyone can get this information. Those people who want it. And even if you're hate watching tonight and you hate the both of us, because I know there's a lot of you out there too, smash the like button on your way out anyway, because we did probably teach you something or clarify some things for you tonight that you might have been really not very knowledgeable about. So there's that. Anything else you got? You got anything else?
If you're into this stuff, there's exhibition Celtics game tonight. Last night they played and won by 50 points in its preseason, but the fact that our coach, who I hated previously, has gone just full psycho and wants to just kill people in the preseason so that when the real season starts, they're ready to go. I'm actually enjoying it. The guy is absolute psycho, but he's our psycho. So embrace it, enjoy it, and hopefully they will destroy tonight's fish food and the season starts next week.
Good. Where can they watch this exhibition basketball? Is it on a regular channel or you have to stream it somewhere?
I don't know. Well, if you're in Boston, it is. I mean, I have the NBA apps and watch this, out of market,
You pay extra for that.
I get the Knicks, right? You get MSG and that stuff.
MSG. Whoever's on MSG, we got it. Everyone out there, thanks for coming. Smash the like on your way out. Cool, be kind, be classy. When I hit the end button, it's going to teleport you over. Go watch Brian at LTL with Nurse Kim. They're going to talk about Enrique Delgado Garcia in about 10 minutes. I'm going to teleport you over there because that's the nice thing to do for those guys, and tell them Cupcake Invasion and that we sent you. So enjoy that as well. Go Celtics. Be cool, be kind, be classy, you guys. Really not hard. If Mark and I can do it, we know that you guys can do it too. Peace out. Good night.
Take care. See ya.